Good morning and welcome to the Appellate Division. I'm about to call the calendar, and as you can see, we have a lot of people here, and that means that there's a lot of time that's been pre-requested for argument. I'm going to ask that you please only request what you actually need so that we're not here for 8.5 hours today, okay? All right, let's begin with People versus Carlos Baez. Okay, submitted. You're on Baez? Who do you represent? You're the appellant? Do we have a respondent?
Yes, Daniel Young representing respondent people.
You're going to get 5, 2, and 5. One thing I will assure you of, if we feel that we need additional time and we're still asking questions, then we will take the time we need for the case. But please try and confine your argument to the time I give you. Densman against Manhattan, eye, ear, and throat.
Ellen, 5 and 1.
Well, you don't have a cross appeal, so it's 5, 1, and 5. Okay, thank you. Matter of Cairo. It's give you 5, 2, 5 for the mother, 3, 4, the attorney for the child. Bisli versus Allen. We don't seem to have a respondent. Do you want to submit? I'll give you 3 minutes. Glaubeck versus Millert.
6 and 2, please. Respondent, 7 minutes.
5, 2, and 5. Swag versus Campiori, and I'm sorry for my pronunciations.
Good morning, Ellen, 7 and 2. Respondent requests 5 minutes, Your Honor.
5, 2, and 5. People versus Davis, submitted. Cologne versus 5's 1/60th.
Appellant, RBR, NNT.
You don't have a respondent. Do you care to submit, sir? 3 minutes. Mountain Valley versus Hilton. You don't have an adversary here. What would you like to do? I didn't hear you. Okay, I'll mark it submitted. Thank you. People versus Donald Lee.
Appellate requests 6 and 2.
Respondent requests 6.
6, 2, and 6. Kinstry versus United Coach Lines.
Appellant 4 and 2, please.
Respondent, 5 minutes, please.
5, 2, and 5. Thank you. Sqn Asset versus Shunfang.
Defendant appellant, Shunfang, we request 10 and 2.
7 and 1 and 7. MF 385 first versus Colutes. Good morning. 3 minutes? All right, so 5 and 3, thank you. Environmental safety versus APS contracting.
Appellant requesting 6 and 2.
5, 2, and 5. People versus Marcus Thompson. 6-2 and 6, thank you. Harris versus City of New York. Respondent plaintiff? We have two respondents here. Six and 2 for the appellant, 6 for the plaintiff respondent, 5 for the city respondent. Signature Financial versus Garber. 5 and 5, thank you. People versus Darnell Hardware.
Good morning, Your Honor. Appellant request 5 and 1.
5, 1 and 5. Thank you. Lamar Vaderpool versus Devora. Submitted. Rosenberg versus Shea. Submitted. Okay, first case up is People versus Baez. Step up, please. You reserved 2 minutes for rebuttal. You have 5 and 2, sir. Right, you did. You're more efficient than you thought, right? Okay. Huh? Okay, we usually have you stand at the podium to argue, and the advantage is because we're all talking with masks that you'll have the microphone, and believe me, it will be very helpful for all of us.
May it please the court. The central issue is that the lower court in this case erroneously assessed 15 points for SORA risk factor 11. The prosecution failed to meet their burden by clear and convincing evidence of showing that Mr. Baez ever abused marijuana within the meaning of risk factor 11. Without these points, Mr. Baez would have only received 65 points total on the risk assessment instrument, and therefore his level should be reduced from the SORA risk level 2 that he received to the proper level, SORA risk level 1.
What about the fact, counsel, that he had previously been in a drug treatment program?
Your Honor, courts have declined to assess points for the mere referral to a substance abuse treatment program when there is no evidence in the record, as there is none in this case, that the defendant was properly screened and assessed for a substance abuse issue. So Mr. Baez was referred, or there is a reference in the PSI, the pre-investigation statement, that Mr. Baez was referred over 15 years ago to a substance abuse treatment program. However, there is no evidence in the record that there was ever a properly administered diagnostic screening and assessment done. And I would refer the court to People v. Cogair, a 4th Department case from 2013, as well as People v. Davis, a 3rd Department case from 2016. In both of those cases, the defendant had been mandated to substance abuse treatment by parole or probation and refused to comply. Nonetheless, the court declined to assess points under risk factor 11, finding that there was insufficient evidence in the record to undergird the referral to substance abuse treatment in the first instance.
How should we assess that in addition he was recommended for a drug treatment program?
I'm sorry, Your Honor?
How should we assess in addition that he was recommended for a drug treatment program?
Well, the evidence in the PSI regarding the instant offense is that the probation officer, Victoria Benton, who completed the screening for mental health and substance use issues, found only that Mr. Baez may benefit from further evaluation and assessment by clinically trained professionals. That is not a recommendation that he complete substance abuse treatment. It is not a finding that he has a substance use disorder. Instead, it is merely a conclusion that more investigation is necessary and that he may benefit from further evaluation.
Well, the standard is not substance abuse disorder. It's whether there has been drug abuse, correct? You don't have to, it doesn't have to be diagnosable. It just has to be proven by clear and convincing evidence that there's abuse.
Well, the standard under People v. Palmer, which has been extended on numerous occasions by this court and all other appellate departments in this state to the use of marijuana, is that in order to prove past abuse, the people must show by clear and convincing evidence that the defendant has a pattern of repeated use to excess.
Correct. That's not necessarily a diagnosable disorder. I don't disagree with you about Palmer. I just think that the idea that there has to be a disorder diagnosed is not the standard in order for the court to find clear and convincing evidence of abuse, of drug abuse, of substance abuse.
The issue here is that there is simply no evidence in the record whatsoever.
I understand that's your position, but I just want to clarify. You're not suggesting that unless there's a diagnosis, that these points cannot be assessed, are you?
I'm not arguing that there has to be a actual label affixed to the defendant that they have a substance use disorder, but I am arguing that there is not evidence in this case that Mr. Baez has ever used marijuana repeatedly to excess. That is still the people's burden to prove, and they failed to prove that. There is no evidence in the record of that, and I would say that, again, he was not referred to a substance abuse treatment program in the current...
You don't have to repeat that, and we're familiar with the record. You don't have to repeat for us. But let me ask you a question. The other evidence that is in the record is that he has used marijuana pretty consistently for 35 years. Would that be enough?
Your Honor, I think the comparison to alcohol here is instructive. The standard deals with both frequency and extent or quantity of use. Somebody who has used alcohol for 35 years by having a glass of wine once a week for 35 years, that does not mean that they have a substance use problem. The same is true of marijuana. In the absence of more evidence that Mr. Baez has ever used marijuana abusively or that he has transgressed occasional moderate use, which there is not evidence of in this record, that does not demonstrate substance abuse within the meaning of risk factor 11.
Thank you. I'm going to ask before you leave the podium, I don't think you interposed your appearance because we started out rather abruptly. So tell us who you are.
Yes, Daniel Hamburg on behalf of the appellant Carlos Baez, appearing for the Bronx Defenders.
Thank you.
Thank you.
Good morning, and may it please the court. Daniel Young on behalf of the people. The lower court properly assigned 80 points to the defendant during his SORA hearing and properly found the 15 points for defendant's history of drug use.
All right, let's focus in on the drug use because I think that right now is the central issue we're talking about. All right, in terms of drug use, let's sort of clear. There is no evidence here that he was under the influence of any drugs at the time the crime was committed, correct?
That is correct, Your Honor.
So the only basis for the assessment of the points under Factor 11 is history, correct?
That is correct.
So tell us, from your point of view, what is the best record that proves by clear and convincing evidence that those points were properly assessed?
Here, the totality of the circumstances presented by the people at the SORA hearing indicate that defendant has a history of substance abuse involving marijuana. We have a defendant here who began using marijuana at the age of 15, and at the time of the hearing had been using it for 35 years.
So, but what do you make of your adversary's argument that it's not just the duration, it's the frequency of use that determines the question of whether there's been abuse as opposed to social use?
Based upon the record presented here, the defendant was ordered to take part in substance abuse treatment as a condition of parole, and defendant failed that substance abuse.
What do you mean he failed?
He did not successfully complete it. We do not have further information as to what happened.
Is that in the record?
I believe it is on the PSR, Your Honor.
Counsel, I'd like to know, what was the reason why substance abuse treatment was ordered as a condition to parole? Do we know the reason?
We are not sure of what the reason he was ordered to complete it. And to answer Your Honor's prior question, I was mistaken. It doesn't state that he failed the treatment. It is that he resumed use of marijuana following the treatment.
I have a follow-up question about the PSR because it also indicates that the defendant was screened for mental health and substance use needs. Do we know when the screening occurred?
We do not, Your Honor.
And the evidence that he resumed it after completing the program, is there any evidence that that was other than moderate or occasional?
Given the defendant's history of use and the fact that there are no periods of abstinence shown in the record, we would argue that he did use more than just occasional use of.
So that's an inference, is that right? So you're drawing that as an inference, right?
Yes, Your Honor.
But there's no actual evidence that his use after completing the program, after being in the program, was more than moderate or occasional. Is
We
that
have
right?
nothing aside from the length of the use and the fact that defendant resumed use after completing his treatment.
So would 35 years of occasional use qualify as abuse for the imposition of points?
It would, Your Honor. It demonstrates a pattern of use beyond just the occasional social use of.
Why is that? I just don't understand. To me, there's a little bit of a disconnect.
Your Honor, it is due to the totality of the circumstances. It's not merely that he used marijuana for 35 years. It's that he obtained drug treatment for it and then resumed usage. And in addition, the PSR indicates that at the time of the crime, he had been using it for over 5 years. So this was continuous usage. There was no period of abstinence that one month.
What is, I just don't understand why clear and convincing evidence is satisfied by the lack of abstinence. Honestly, and I think the analogy that your adversary makes to the use of alcohol is instructive, isn't it? I mean, you drink a glass of wine once a week for 35 years, you're 60 years old, is that abuse?
That would not be abuse, Your Honor,
Sure,
but
it
here there's no indication that there was any period in which he wasn't
I
taking.
understand, but isn't it your burden of proof to show that he did abuse? And can you really show it with the lack of abstinence?
The lack of abstinence is merely one part of it. It is due to the entire, I see my time has run, if I may.
You can finish your answer.
It is due to the entirety of the circumstances here. The defendant began smoking marijuana at the age of 15. At the time of the SORA hearing, that meant that he had been using marijuana for 35 years total. The PSR indicates that at the very least he had been using it for the 5 prior years, and he was assigned to take a drug treatment course as a condition of parole, and following that parole, he did resume usage.
Thank you.
With that, I ask that this court affirm the lower court's determination. Thank you.
Thank you.
May I begin?
You may.
Okay. Your Honors, the respondent here is conflating longevity or duration of use with abuse. That is not the standard. 35 years of occasional use is contemplated by the guidelines and permitted under the People v. Palmer standard and its progeny. There is simply no evidence that that Mr. Baez has ever used marijuana more than on an occasional basis
Counsel,
over the course of his adult life.
Did the court give any reason for the assessment of these 15 points for the factor 11?
The
all?
court did not indicate its reasoning. The fact that Mr. Baez has used marijuana following his referral to a drug treatment program over 15 years ago as a condition of parole is immaterial. As this court stated, the standard is—
It's not inconsistent with occasional use.
Correct. Abstinence is not the standard. And especially here where there is no evidence that he was, for why he was referred to that substance abuse program in the first place, the fact that he has engaged in occasional moderate use in the years following that does not indicate abuse.
Thank you.
Thank you.
Thank you both. Right, the next case is Densman versus Manhattan, eye, ear, and throat. You may proceed, Counselor.
Good morning, may it please the court. Michael Zhu, of counsel to Thomas Hochberg, attorney of record for Pearl Densman. The trial court erred in granting the defendant's motion for summary judgment dismissal of the complaint on the grounds that her belief that she was optically confused because of the difference in color between the last step and the light-colored floor. That's really wasn't her testimony. That's not the basis for her confusion. The record reveals that she clearly testified that as she was walking down the steps, she sees 4 black steps that were carpeted that had a black edging. And then the 5th step is a light stone colored without any edging on the end. The banister and railing, the railing and the handrail and the posts end where these 4 black steps end. From her perspective, and you could see it in the photograph at page 323 of the record, from her perspective of walking down the stairs, it appeared to her that the steps ended where the 4 black steps ended.
What about the fact, though, and this seems very important, that the next surface after that step was a completely different surface? So once you stepped off that last step, there was another surface below that was a completely different color and a completely different appearance. So doesn't that negate the argument of an optical illusion?
Well, I would agree that there are contrasting colors between the beige and the blue. But before you even get to that, from the plaintiff's perspective, all she sees is the beige step, thinking that that's where the floor starts. So the floor may continue with a different color, but from her perspective, that stone step was where the floor was.
Well, doesn't there have to be really an objective element to this too, in terms of whether there is the basis for her confusion about where the steps ended? In other words, in order to create a hazardous condition?
Well, no, because this court previously held in Nin in 1999 that the issue of whether a dangerous condition exists in the first instance depends on the peculiar facts of each case and is generally a question of fact for the jury. So,
Counsel, what makes this case different than a case like Francini or a case like Hall, which have very similar, and Nan, that have similar fact patterns to this case and similar conditions? And in all those cases, the court held as a matter of law, it was not an optical illusion. It was open and obvious.
Because the plaintiff here testified that she understands that the stone step and the floor were different colors, but that's not the reason for her confusion. The reason for her confusion is the carpeted steps and the stone step were of a different color. The handrail ends at the carpeted step. So from her perspective, as she's walking down, again, 323 of the record, as she's walking down, she sees a light-colored stone step. She doesn't realize that it's a step because the handrails end at the carpeted step. So from her perspective, she sees the floor.
From her perspective, but for a reasonable person to look at those photographs, is it your argument that a reasonable person looking at those photographs would not find the condition to be open and obvious?
Yes, it is. I mean, again, not to repeat myself, but 323 of the record, her perspective looking, if you look at the posts on the handrail, it's the same color as the stone step. So as you're walking down and as you're looking down, and there are other people in front of her at the time, but not necessarily blocking her view. But there are other people around, and as she's walking down, she sees a light color on the floor where the banisters end, and to her, that's where the floor was.
Counsel, my other concern is that your expert seems to base his opinion in part on the similarity of the color and the last step, of the last step and the floor beneath it. And I just can't understand how anybody looking at the last step and the floor would consider the two colors similar. So it seems to me, why wouldn't the court have been justified in completely disregarding your expert's testimony, which was based on a counterfactual conclusion?
Well, I don't necessarily need Mr. Fine's affidavit here.
So
I'm
you're not
on-
relying on Mr. Fine at all?
Well, no, I'm not saying I'm not, but I don't necessarily need it to establish my premise here
I
that
see.
there's a question of fact as to whether the plaintiff was confronted with an optical illusion, a confusion. And also, the trial court also erred in dismissing the action and rejecting the plaintiff's claim that the lack of a handrail at the
You'll be
last
able to
step.
address that in your reply, because you're out of time right now.
Thank you.
We'll talk about that.
Good morning. May it please the court, my name is Joseph O'Connor. I represent the respondents, Manhattan Eye, Ear, and Throat Hospital, Lenox Hill, and Northwell Health. I believe the matter comes down to the photograph that was referenced. It's on page 318 and 319. The plaintiff, when she testified, indicated that it fairly and accurately depicted the appearance of the steps.
Well, let me ask you something. I think we all probably looked at all of the pictures that were in the record, and there was at least one of them where it could have been a little confusing as she was walking down, even though I think we all agreed that the last step was not the same color as the floor or the same color as the 3 or 4 carpeted steps above it. But couldn't it be as she was walking down that it might have caused, in the second that you're walking down, some kind of confusion? And should we be making that decision on a motion as opposed to sending that to a jury to determine?
Well, initially she didn't trip as she was stepping from the dark charcoal colored steps onto that beige granite step. She tripped as she was stepping off the beige granite step onto the blue vinyl floor. So I think that's kind of misleading in a way. That really didn't have an impact. I don't think the testimony supports any other conclusion. It's clearly different in color, consistency, the floor is shiny as opposed to a dull gray stone. There's no defects found. My expert looked at it, Mr. Shabansky. He looked through everything, every code that was applied. There was no code violations. There were no problems. And in fact, the stairwell with the railing where it ends at the newel post, which is one step up, if you will, if you actually go downstairs today, you'll see that you have 2 steps that extend beyond the newel post. And the reason that that's permitted...
We can consider ourselves on notice. What? Go ahead.
I don't think you need to be. I think because it's a grandfathered statute. The pictures are evident, and she also testified she wasn't sure that she was looking at the ground, and testified that she noticed it after she fell. Said, "Oh, look, it's a different color." So I don't think there's really testimony to support the contention that she was somehow misled by the appearance.
Can we turn to the...
I'm sorry.
Go ahead.
Counsel, what safety standard did plaintiff's expert cite with respect to the contention that handrails were required at the last step?
Yeah, absolutely none. They apparently concede that the code was followed because it is grandfathered in. There was no specifications that were claimed to be violated. It was just a conclusion. And I think the conclusion and the reason for the claim that there's a similar color is because when Mr. Fine went to examine the property, it was after renovations had been made. And oddly enough, all of the stairs now are gray in color. So there's less of a color disparity than there was back when the accident happened.
But the handrail still doesn't go all the way down, is that correct?
That is correct, nor does it need to.
Right,
just like
and
it doesn't need to.
we do have some case law, and she did testify consistently with this, that when she went to break her fall, she reached for a handrail that wasn't there. Is that enough to support her claim?
No, if the governing body, the legislature wanted a handrail to extend, as it does on newer construction, they would have made the provision retroactive. There are no violations of any nature. Just the fact that we're permitted by statute in the building code to stop the handrail one step from the bottom doesn't create a viable claim. There's a way to hold on to that and exit down, as everyone here probably did this morning on the way down to the first floor, to the lower level.
All right, thank you.
Thank you very much.
Okay, you can proceed, and you can address the handrail
Yes.
now.
So
please.
on the issue of the handrails,
Right.
the trial court held that, as a matter of law, that the claim is not cognizable because there was no testimony that she grabbed or reached for a handrail, and that's
In fact,
not-
there was.
in
She
fact
did-
there was, yes.
But is that enough under our case law? Does there have to be an industry-wide standard, be it the building code or something else, that otherwise requires that a handrail go all the way down the staircase? And where is that standard in this record? Did your expert provide that standard?
Well, Mr. Fine did say that it was contrary to custom and practice. Now, the defendant's argument that they complied with the 1905 building codes is not relevant on this issue because under the Court of Appeals decisions in Kelman and this court's decision in Kelly, a defendant's compliance with building codes does not obviate a duty to does not obviate a common law claim based on industry standards and practice, which Mr. Fine does go into to say that the absence of a handrail that goes completely down to the end of the staircase is a violation of custom and standards. The other issue, and counsel pointed this out, with the staircase here, if you can go down, you'll see all the staircases are the same color. So they're all brown, and they all have black striping at the edge to lead the eye.
I'm going to ask that you wrap up.
Sure. Okay.
All right. With all due respect, and I'll say it in front of everybody, even the 8 hours that we had that I cut everybody down to, we still have over 3 hours of argument today. So
Understood.
I'm asking everybody to really confine themselves to the lights today.
Understood.
Yeah.
Just to conclude, the plaintiff's testimony here supports a finding that there's at least a question of fact as to whether she was optically confused based on the difference in color of the 4 steps and the stone step. And on that basis, we ask that this court reverse the order of appeal from. Thank you.
Thank you. All right, the next case is in the matter of Cairo. Step up, please. Okay, you can proceed, Counselor.
May it please the court, my name is Jameson Davies for the appellant ACS. At the outset, I just want to make the court aware that yesterday there was an order entered expanding visitation and allowing for overnight visits. ACS is planning to move for a stay and appeal of that order, and we don't think that moots out this case, but I wanted to make the court aware.
Overnight visits with the same condition of the two parents being present at the same time?
My understanding is the unsupervised time, which was expanded to 5 hours, the court departed from this court's order and said that they could be individual. I'm not sure if that condition also carries over to the overnight visit.
So weren't the children put into the custody of the maternal grandmother? Are they continuing to live with the maternal grandmother?
They're still in the custody of the maternal grandmother. I believe that she had a COVID contact, and they were briefly placed with the aunt because they couldn't. The grandmother was isolating, but there was still a supervision that was approved by ACS.
So what's the overnight situation? Because I thought that the parents were actually staying with the maternal grandmother.
Sorry, the new order would be unsupervised overnight visits. The current order was...
So they would go back to the parents' home outside, not with either the maternal grandmother or the aunt necessarily?
Correct. That's my understanding, Your Honor.
So you're saying the order is at odds with our interim order here?
Yes, I believe that's correct because of the additional permission of the parents to have separate unsupervised time with the children. And I think my understanding is that ACS will be moving for a stay of that order sometime today.
And is there any date for final disposition?
I don't think that there's been a date, no.
I thought the trial was scheduled for January.
That may be the case, Your Honor. I'm not certain if the date has been set. I know there was the permanency hearing yesterday, but I don't know if they set the date for the trial. Or if they changed the date from what...
Yeah, I think, honestly, and I know we're not necessarily arguing the merits of this particular application, but it just shows you how time changes these cases in a rapid way.
Yes, I agree, Your Honor, and even though this appeal was on an expedited calendar, it did get pushed to term, and
When is the stay application? Because they are interrelated, obviously, the stay application and this application, and one impacts the other. Do you know when that stay application is going to be submitted?
my understanding is ACS is going to submit it today,
Today.
if it hasn't already been submitted. I had to turn my phone off, so I don't know. I haven't gotten any emails about it, but they told me that they will submit the stay application today.
Okay.
But of course, that's based on additional record evidence that we don't have, right? I mean, I assume that there was some kind of evidence given to the trial judge to modify the interim order that we don't now have. So it's hard for us to evaluate that order since it's not in front of us and was based on the evidence that we don't have.
There is probably additional evidence. We didn't have the transcript yet. We did have a report that was submitted, but I don't think that the evidence is of a character that changes the underlying issue here, because the main evidence that has been cited in support of the order is just the parents' continued compliance and the continued lack of injury to Cairo, which we argue is not sufficient to allow unsupervised time because of the severity of the injuries, because of the unique vulnerability of the child as an infant, and because there's very little downside to supervision where they have extensive family contact. If I could turn to the merits, unless the court has other questions. The family court's order permitting unsupervised time should be reversed because the evidence showed and the family court found that the child was at imminent risk of harm if returned to the respondent's unsupervised care because of the severe unexplained injuries, including 16 rib fractures and 2 pleural effusions, which is where the rib...
So, counsel, the evidence that the child's injuries had to have been post-birth was all hearsay, correct? There was testimony by, I believe, an ACS employee describing what a doctor had said to the ACS employee. There was no actual testimony by a doctor that it had to have been caused post-birth, right?
No, that's not correct, Your Honor. The doctor did testify at the 1028 hearing, Dr. Miller, and he said that because of the time frame of callus formation, which basically tells you how long it's been since a break happened, that it couldn't have been from childbirth. The calluses had basically not started to form when the infant was initially seen and started to form a bit thereafter on subsequent x-rays, which indicated that injuries happened sometime in the prior 2 weeks before he was initially admitted to the hospital. So that the doctor ruled out that it could have been a complication from childbirth.
And wasn't there also hearsay testimony by another, which is, of course, is admissible at a 1027 or a 1028, that another doctor had opined that it could have occurred as part of the birth process?
I'm not aware that there was another doctor that opined that it could have been as part of the birth process.
As described by the mother's testimony at the hearing, and therefore it was hearsay, but that's admissible at a
Oh, I'm sorry. Yes, the mother did say that someone had told her. Yes, that's correct, Your Honor. That someone had told her that it could have been. I don't think it was identified as to who that was, but she did say that because of the complications that someone had told her that was a possibility.
And I know you're over your time, but I'm going to ask you another question.
Of course.
Did the family court judge make any finding of fact at these preliminary hearings regarding the cause of the rib fractures?
The judge did say that based on the evidence, which was undisputed, that these are the types of injuries that could only have been caused by the intentional application of force, and the admission of the respondents that they were the only ones with custody of the child, that it was likely that someone had intentionally caused these injuries, knew that they had caused them, and one or both of them was not coming forward with who had caused the injury.
Okay.
And that was the basis of the court's imminent risk finding, which the court did not retrieve from in its later order.
Okay, thank you.
May it please the court, Jessica Haran-Block from the Bronx Defenders for the mother, Mylana G. I want to start with the permanency hearing that occurred yesterday. I was present at that permanency hearing and represented Mylana G.
Counsel, I'd like to focus on the order that's in front of us. As I understand it, the primary relief that ACS is seeking is that the two parents be required to spend their unsupervised visitation time together with the child. Why is that a bad idea?
Well,
and why is that? I mean, why is that a problem for your client? Why?
Yeah, it's not necessarily a problem in that the parents spend a lot of time together. They are together. They live together. One issue is that, it's two issues. One is that, it's our assertion that a parent's alone time with the child, not specifically always with another parent or being watched, is critical to bonding between a parent and child. And in fact, the court recognized that yesterday when he ordered that the parents could start some separate visitation. But in addition—
Isn't that order in violation of our stay, though?
Yeah.
I have to say, I'm a little surprised to hear that. I mean, at least when he extended the time, it was within the parameters of the supervision that we had established on the stay motion. So I have to say, I'm a little surprised.
Well, I will say yesterday, the ACS brought to court a court report where they indicated that the unsupervised visits were going well and that they were interested in increasing the unsupervised visits.
That ACS was?
Yes, they
But having another person present, even if it's the other parent, is a measure of safety because one is looking over the other, right?
Yes.
I mean, it's not great. Nothing's great here. Nothing is a perfect solution here, but there is some rationale behind it that makes some sense. It's not really off the wall.
No, what I will say is that the parents have both work full-time, and the mother works actually in the Bronx Criminal Court.
I saw that.
8 to 5 every day, and the father works retail in a mall. His schedule's 2 to 11 p.m., so the amount of time they actually have together where they can be unsupervised with the child is on the weekends. I will also say that the court order allowed, the court order from July allowed an ACS, and my understanding did not appeal, that the parents can take separately the child together to doctor's appointments.
That's correct.
And
but what you're talking about is totally different. You're talking about something totally different. And there's no question that the burden of some supervision is going to burden people who work or who are parents or who don't work, and that it's a balancing. of safety versus the reunification if it's possible, right?
Yes, certainly, and I think in denying the 1028 application and finding imminent risk, the court took into consideration the fractures, but also took into consideration that the undisputed evidence that there was no other concerns about this family. He found the mother credible, he found her devoted, he found that she took every step she needed to take, and that this was a very narrow order that the parents could have 90 minutes alone. And I just want to note, he entered other protective orders, right? He entered an order, there's a limited order of protection. He entered an order that ACS has to submit a court report on the 1st of every month. He entered.
Yeah, I understand that, but in looking at this and making the balance, and I understand that your position is we should defer to the trial judge who was in a position to see what was going on. However, his universe, as is ours, is limited at this point because it was an emergency hearing, and in fact, until we have a full hearing, where we can get more facts on both ends of the spectrum, the balance of reunification versus the seriousness, nobody can dispute the seriousness of this child's injuries, and at best you could say, from your client's point of view, of unknown origin, although there are questions regarding why a parent wouldn't know that their child had multiple fractures or the origin, or have some reason to, other than what was proven here, that, or what was initially credited here, that somebody deliberately did this to the child. So for me, it's an undeveloped record on which to decide the balance in such a way as to give the child to the parent without some kind of safeguards in place.
Yeah, I will say that it was an extensive record. The judge did hear from both parents, 3 witnesses, and notwithstanding the injuries. And I will say also, though the judge found what counsel indicated, that this was likely someone exerting some force, there was a genetic, the child was found to have a genetic anomaly on the LRP5 gene.
Well, was that at the hearing, or was that out of the mother's mouth, or was there a doctor who came in and testified to that? I know that's a working theory, and that will be fleshed out in the full hearing, but was there really a record of that?
Yeah, if you'll allow me to answer, there was a genetic, there was at least 2 reports entered into the hearing about the geneticist, from a geneticist indicating that there was an anomaly, there was a mutation on the LRP5 gene that can be associated with issues with the bone. And in addition, the attorney for the child called a pediatric radiologist who indicated he could not rule out that significance. And I just want to point out one recent development, which was also presented in the family court, which is that the child has been subsequently seen as recently as last Friday by the director of pediatric bone health at Mount Sinai, Dr. Chemry Robinson, who submitted a report to ACS, who provided, and we provided it to the court yesterday, who indicated that we now know that the mother has this genetic variant. She testified that she's had multiple fractures, and she's only 23 years old. And so it's a very real possibility now that there is an explanation for why the parents wouldn't know that they were causing these rib fractures. In other words, there may have been a genetic predisposition for the child getting these fractures. And the parents certainly know, I will say, something was wrong with their child. As the record indicates, they had 2 telehealth appointments, they went to the ER twice, they were trying to seek, frankly, no one wants an explanation more than my client, Your Honor.
Okay. Thank you. Thank you.
Good morning, Amy Haskinick, Legal Aid Society, attorney for the children. We did support the family court order.
Right, and let me just clarify, because I didn't see in your brief, and I may have just overlooked it. Because the children are so young, the baby and even the sibling, this is a substituted judgment case, correct?
Yes.
Okay.
And the order did take into consideration the injuries, and the children were not returned to the parent, but placed with the maternal grandparent. We do support the 90-minute unsupervised time because the goal is return to the parent. The parents have been engaged in services, and there have been no other further safety concerns. And the visits are sandwiched. So you have someone that's been cleared by ACS or ACS themselves, the beginning of the visit and at the end of the visit. So we thought that things had been
And
thought
do you
through.
have a position on the parents being required to do the unsupervised visitation together?
I actually think they should be together, yes.
So you do support
We do support the modification that was presented by this court.
Okay.
So, and to your knowledge, are these new overnight visitations, are they consistent with that provision?
That's the overnight that was just put in place yesterday. We did not support that. We supported the unsupervised, but we did not support the overnight visits at this time.
Okay. Anything further? Okay. Colleagues? Thank you. Difficult. All right, we have a rebuttal.
Thank you, Your Honors. I'll be brief. I just want to seize on a point that Your Honors made, that this is a preliminary stage, given the severity of the injuries and, you know, the lack of explanation at this early stage.
Well, what about this situation that counsel brought up about the reports from the geneticist? I mean, that's fairly.
Yeah, so there is
And when you say there's absolutely, you know, no explanation, I'm not saying that's definitive, but that's, you know, you don't probably get that in many cases.
correct. Two responses, Your Honor. First is that at the hearing, at the 1028 hearing, the doctors testified that if there was a genetic abnormality, you would expect to see more breaks than it happened now, and they wouldn't happen all at once in the way that they did here. And even if there is a genetic abnormality that makes it more likely that he has bone breaks, that doesn't necessarily rule out the application of force that caused these breaks. It just makes them more likely to have happened. I'd also just like to point out the letter that was referenced from the doctor shows, I'm quoting from the letter, it's not entirely clear whether the variant could lead to decreased mineral density, unlike a loss of function mutation in the LPR5 gene. So there is a genetic anomaly that's associated with this kind of bone density, lack of bone density, decreased bone density that has been identified, but this particular variant that this child has not been proven to be associated with the same lack of bone density. It's unclear at this point. And to the mother who has the same variant, she didn't have any early childhood fractures. Her earliest fracture, I think, was in middle school playing sports. So it's not the same situation necessarily. But the real point is that this is stuff that's going to come out at fact-finding and on a preliminary basis, given the testimony of the doctors, that if there was a genetic cause, there would be more likely to be more breaks. At this juncture, the risk of harm is so significant, given the severity of the injuries, and the imposition of supervision is relatively minimal. We think the balance weighs in favor of requiring supervision.
So can I just understand, because I know we put in a TRO in this court, and then in September, family court changed it. What exactly is it that you're seeking today?
Today, we're seeking, we think that the subsequent order is based on this underlying finding that the parents are able to have unsupervised time with the children without significant risk. And since that subsequent order flows from this order, I think a reversal, and that order will also be before the court shortly, so they could be considered together if the court wants to do so.
I'm actually request.
I'm sorry?
Have you put in that request when, in connection with this application, that it is related to this appeal?
Well, the notice of appeal, I think, will be filed today, so we haven't had the chance to.
Well, I'm actually going to give you a direction today that when you bring in the order to show cause, you need to notify the clerk's office that this appeal is on today, and we believe that it's a related motion, because then the motion will probably come to this bench.
Okay, yes, I'll tell,
right.
unless they have filed it already, but I'll tell ACS.
Well, even if they filed it, you can call them up.
No, yes.
I'm sure it hasn't gotten to an interim judge yet.
Of course, of course.
So I'm giving you a direction. I'd step off the bench myself, but we're a little tied up right now, so
Several
I'm going to put it
hours.
on you. All right?
Let the clerk.
All right, and your adversaries are on notice too, that, you know, they may have to be available to talk to an interim judge for a stay, or possibly one of us later today. Okay? All right. Thank you.
Thank you, Your Honor.
Very difficult case.
No, it's crazy. You go crazy. Right.
Okay, Beasley against Meadows Office.
Good morning, Your Honors. May it please the Court, Albana Petrakov of Offit Corman on behalf of Bisli Inc., plaintiff appellant in this case. The central issue here is whether the motion court prematurely and improperly dismissed the conversion claim against defendants respondents Marissa Allen and Sherry David. The standard to be applied on a motion to dismiss is...
We're aware. We're aware. Don't worry about that. That
Yeah.
we know cold. Go ahead.
So our position is that viewed against the correct standard, appellant should be permitted to proceed.
What are your allegations that support a conversion, particularly as it applies to money?
So with respect to the assertion by respondents that this is a duplicative claim of the breach of contract, there are two different sets of facts. Bisli delivered its product to the end customer, and the project was going on between February and August. Within this time frame...
Because I only gave you a couple of minutes, we are really aware of the record, all right? So I want to assuage any concerns you have. So you can get right directly to the point. What was the mistake the lower court made?
Ignoring the
the
allegations in the complaint that in August, the intervention of the institutional customer in the relationship between Meadows and Bisli changed this relationship.
So you asked a specific legal question. How can there be a claim for conversion where it's undisputed that your client never had ownership, possession, or control of the funds? And is there a case that supports a claim for conversion in the absence of ownership, possession, and control of the funds?
Your Honor, with respect to the timing of possession, it doesn't have to... Bisli received the right to immediate possession based on the instruction and the earmarking of the funds. If I may direct Your Honor's attention to Bankers Trust Company, Viscerato, Sweeney, and Con, 187 AD 2D 384. There, the plaintiff was an assignee under a letter agreement assigning settlement proceeds. The assignee didn't have possession or control over the settlement proceeds before those payments were made, and the defendant there misappropriated and converted those funds. So there was no, the case law allows conversion cause of action even when there is no immediate possession prior to.
Okay, thank you.
Thank you.
Okay, the next case is Glaubeck versus Graubard Miller. Step up, please. You may proceed.
Good morning. May it please the court. I'm Andrew Bluestone. I represent appellant. The mistake made by the lower court here was first reliance upon the amended complaint as documentary evidence which utterly refuted the claims.
Counsel, let's go straight to the issue of standing, since that seems to be a very pertinent issue.
Yes, Your Honor.
How can your client possibly have standing to bring this malpractice action where it is undisputed that any recovery in this action, whether it's an individual or a derivative claim, would go to the corporation and not to the individual? So what gives your client standing?
Two things. First, it's not undisputed that damages from this case would have to go to personal touch.
Well, there's 720 causes of action, right?
Yes, but those are not, that's only half of the claims. The second half of the claims, which are over $5 million, are for attorneys' fees paid for negligent work. Those go back to Mr. Glaubeck without a question. Beyond
mean
that,
without a question? Why do they go back to him?
because he
I
paid them.
don't, yeah, but that doesn't mean that they go back to him under a theory of malpractice.
Of course they do, Your Honor, because he paid those damages. These are not claims that are lost.
Yeah, but
These
the
are attorney's fees.
I don't see that that is an of course. Do you have a case that supports that? Honestly, I don't.
Well,
Maybe you're right, maybe you're not. I just don't see it as an of course.
I believe I don't have a case offhand from right now, but if he's the one who paid the fees individually and as derivative claims, and the fees were negligently, the case
But
was
if he paid the fees, he paid them on behalf of the corporation. Isn't his claim against the corporation
No,
for the fees?
no, Your
Or on
Honor.
some,
He paid them individually. And one of the things that we know
it
is that
wasn't
he,
represented individually. They brought a derivative, or the idea was they were supposed to bring an action on behalf of the corporation, derivatively and under 720.
derivatively under 720 and individually for his losses of the $600,000 in the report that was undertaken.
So why wouldn't any claim, if he had a claim to get reimbursed for the attorney's fees he incurred on behalf of a claim the corporation was pursuing, why wouldn't that claim be against the corporation? I laid out the attorney's fees. You were successful in the claim corporation, therefore reimburse me for the expenditure, basically, because it's the corporation's claims.
Because the corporation didn't put out the money.
We understand that.
And he's the only person in this universe who can bring this action against the attorneys in order to bring back the money.
Well, this
The
action,
corporation can bring it.
yeah, this,
Sorry?
he could have brought it derivatively here.
He did.
I mean, it was,
He did, Your Honor. If you look at the caption of this case, you'll see that he brought it derivatively and individually. I was quite careful to put it that way in the caption, although that didn't happen in the underlying case, which is what this court found was the departure.
it wasn't this court, right, it was the second department, right.
Excuse me, it was the
It was a
appellate division.
different, right, it wasn't us.
But the appellate
It was
division,
a court of concurrent jurisdiction, right?
yes, found specifically that the problem with the case was not substantive. Remember that summary judgment had been granted to Mr. Glaubeck, to Dr. Glaubeck, but it was pleading. It found that because the amended complaint indicates that plaintiff is suing derivatively in his capacity as a shareholder and not in his capacity as an officer and a director, the demand requirement applies.
Right.
He should have been
Right, I don't know
named.
if that, right. I don't necessarily agree with you about procedural and non-procedural, but that was the rationale, right?
That was,
Demand futility had, or a demand or demand futility had to be pled.
as a shareholder, but not as
As
an
a-
officer or director. And had they pled him correctly as an officer and director, which Supreme Court here in the underlying case said was done through the body of the complaint and therefore was good enough, then the appellate division would not have reversed.
Right, that's on the merits, but that doesn't affect standing here. Again,
I agree
whose
with you.
remedy is this?
But if you look at the
Can I
complaint,
just
Your
go
Honor,
back for a second, because I'm looking at the caption here that you said was a derivative claim. It says, individually and in his capacity as a board member.
that's the derivative claim.
That's a derivative claim?
Of course it is, yes.
It's not on behalf of the corporation, it's in his capacity as a board member of the corporation. That doesn't say he's bringing it as the corporation.
That indicates that he's derivatively claiming on behalf of the corporation of which he's a board member, officer, and director. If you look at the amended complaint that Supreme Court
And this will
relied...
be your last point, and you'll have time on rebuttal. Go ahead.
Yes, Your Honor. You'll see that the parties, that defendants here pled plaintiff, Felix Glaubeck, by his attorneys Graubard and Miller, as and for his amended complaint. That in and of itself confers standing. But he paid the bills, he retained them individually, and they failed to name him individually, which is what the main problem in the case was.
Okay, thank you.
May it please the court, David Bain from Ackerman LLP for respondents. I'd like to start by responding to this claim that this case has somehow been brought derivatively. That's not true. There's no derivative action here. This is not a BCL 720 cause of action. This is a claim for legal malpractice. The court below correctly dismissed the amended complaint for
Well, let's get back to the issue of standing. Does the fact that he paid the legal fees, is that sufficient for him to sue in malpractice or whatever causes of action he's bringing here to get that money back?
No, Your Honor, because
Why not?
Because he could not have recovered them in the underlying lawsuit. BCL Section 720 does not provide for an award of attorney's fees to the prevailing plaintiff. So therefore, under the American rule, he would not have recovered attorney's fees. To the extent he has some claim that if there had been a successful derivative action, any claim for attorney's fees to the successful plaintiff would have to come from an award to the company. So therefore, that claim is derivative as well. Without a pot of money, without a money from the awarded to the company, either in the underlying action or in a malpractice action, there is no claim for Mr. Glaubeck to obtain attorney's fees. Your Honors are correct. Any claim he has for that is against the corporation. So,
well, then let's deal with the underlying merits. Let's just say we get beyond standing. We do have the second department case. So was the lower court correct in looking at the complaint that the second department found was inadequate in order to find that there was no malpractice?
well, the standard of care, Your Honor, has to be measured at the time the legal services are performed. And at the time this amended complaint was drafted in the underlying case, Connaught v. Schnall was the leading case in pleading a BCL 720 cause of action. All that it required is that you allege that the plaintiff is an officer or director of the company, that the company has suffered a loss caused by the misconduct of other officers and directors, and that the case has been brought on behalf of the company.
Are you saying that the second department decision was incorrect?
I don't know why the second department ruled why it did. It never addressed
But aren't we stuck with that, at least for pleading purposes here? And I'm not saying they ruled incorrectly. I don't even want to infer that. But they ruled what they ruled. Do we look behind that?
That's correct, Your Honor, but you cannot judge an attorney's conduct by things that happen years later. Attorneys are not judged by a standard of infallibility. The standard of care for legal malpractice just requires that they act competently and adequately under the circumstances as existed at the time. The pleading they put in states, as the court noted, that Mr. Glaubeck is a special director of personal touch and pled it twice, and also stated that it was bringing the causes of action under BCL 720. So objectively, based on the pleading standard in 2016, when they drafted that pleading, it was adequately pled. For some reason, the second department decided otherwise, but it never addressed the specific allegations that the court below relied on in determining that the pleading was adequate.
Just so it's clear that your position is there's no standing and we don't even need to get to the issue of
That's
legal
correct.
malpractice, right?
That's correct, Your Honor. And there's also a third issue here of successor counsel.
Let me just be clear. I just want to understand your position with regard to the second department decision. Are you suggesting that we should disregard that or look behind it?
I'm suggesting that the second department's decision is not dispositive and not even particularly relevant to whether my clients, the respondents, met the standard of care in 2016. The Connaught v. Schnall was the standard for pleading cases, BCL 720 cases, and no cases have gone the other way.
But this is a pleading motion, so doesn't that at least go into the issue of the merits that arguably there is malpractice here? I mean, maybe your argument is correct that it's not the standard of care in the second department, but as the law is stated in the second department, but wouldn't it suffice at least for pleading purposes?
But in a motion based on documentary evidence, which is what this is, a 3211A1 motion, the court can look at the actual pleading and make a determination as to—
Sure, but you're also asking for a determination as a matter of law regarding the standard of care, that the standard of care has been met. Now we seem to have a dispute about what the standard of care is.
Well, I don't think the appellant disputes that Connaught v. Schnall was the applicable standard of care in 2016. We cited cases in our brief showing that the standard of care may be determined on a motion to dismiss, including the Baez case from the Court of Appeals. I would like to just briefly bring up that if there was any problem with the pleading, successor counsel had an ample time and opportunity to cure it. The Jones Day law firm came into this case in 2016, and there's no allegation that they saw any problem.
That's a different issue, that's a different issue.
Yes, Your Honor,
Okay,
but it's an
thank you.
independent basis for affirming the court below. Thank you.
On that different issue, Your Honor, the second department also reversed, or they found that it was late and there was prejudice to the defendants in a 2021 decision on the successor counsel issue.
Counsel, why would the fact that an appellate court later finds that something is incorrect, which happens not infrequently, be a basis for malpractice against a lawyer? Does that mean every time a lawyer advises something and the trial court agrees and the appellate court later reverses, it's malpractice?
Well, I guess the appellate court has the higher voice here and saying
Yeah,
that.
but just because they're saying you got a piece of law, we disagree with how you interpret a law, that means it's malpractice?
They didn't disagree with how they interpreted the law. They interpreted the amended complaint to be insufficient as a matter of law. And these attorneys created the amended complaint.
So you're saying every time an appellate court dismisses a complaint for being legally inadequate, that's malpractice on the part of the attorney?
If it's a pleading issue and not a factual issue, yes. If there aren't any facts to support the claim, that's one thing.
That's true. Won't we have a lot more legal malpractice causes of action floating around?
That would be fine. But yes, you would.
That would be fine. I don't know.
The point is that once the appellate division decides that the pleadings were insufficient as a matter of law, that implicates the creator of the pleadings. There's no argument about that I can see.
Okay.
Thank you.
Thank you. Thank you both. Burinswag versus Campiori. Next case up. Okay, you can proceed, Counselor, and you can start by telling me how your clients, never mind, go ahead.
I'm sorry, Your Honor, I didn't hear you. Can I start with?
No, I'm withdrawing what I was going to say anyway. I'm going to just let you go forward on your.
Thank you, Your Honor. May it please the court, Abe Reichik from Katz and Reichik, representing the appellants Chalk Point Kitchen, 525 Broom, and Indy Fork. This is an eatery that contracted with Grubhub, an online mobile prepared food ordering and delivery platform.
Isn't your motion here a little premature? I mean, don't we need to have a little discovery to figure out what was going on? I saw a contract, but it was a year later, so that doesn't really help for what was going on there. So how could you move and expect a granting of a dismissal at this stage? Don't we have to know a little bit more?
Sure, Your Honor, but the law, and I heard the court say earlier that it's well aware of the standard on a motion to dismiss.
Well, obviously.
Certainly, where documentary evidence has been.
We don't know that by now, we're in trouble.
Documentary evidence has been submitted. Here, there is no dispute. The facts in the complaint are in error. They're flatly contradicted by the evidence.
Let me stop you for a minute, because you're talking.
I'm sorry.
What are they contradicted by?
They're contradicted by the contract. There's no dispute.
But the contract doesn't apply.
But
it wasn't in effect at the time of the accident, so that's not documentary proof. That may be some evidence of what their relationship may have been pre-contract, but it certainly isn't documentary evidence for a 3211 motion.
there's no dispute, Your Honor. Everyone that has submitted papers on this application, except for the plaintiff. I want to remind the court that this was a combined motion, cross motion.
Counsel, let's go back a minute. What evidence is there that this bicycle rider was not an employer other than the affidavit of the restaurant owner, which is not normally sufficient for a motion to dismiss? What other evidence is there, concrete evidence,
Sure, Your Honor.
as to who this bike rider was or was not an employer?
Not only is there the contract between the restaurant and Grubhub, which, yes, is dated a year later, but Grubhub admitted in its papers on the motion, and Matthew Levine in his affidavit also indicated that was
Okay, so
governing
that's
the
an
relief.
affidavit, but this is a motion to dismiss, and since we're talking about standards on a motion to dismiss, you can't win a motion to dismiss by submitting an affidavit contradicting a factual averment of the plaintiff. That's not how you win a motion to dismiss. So that's not a basis for granting a motion to dismiss. So what other basis is there?
That wasn't the only evidence before the court, Your Honor.
What else is there other than a contract that's dated a year later? So that clearly can't be either. What besides those two things supports a motion to dismiss?
Sure, Your Honor. There's also Campiori's partner delivery agreement, and there's also Campiori's affidavit, where he says that he was an independent contractor.
But again, I mean, I have to reiterate what my colleagues are saying. I mean, there's a lot of affidavits in here, but affidavits are not, that contradict what the complaint says. So don't we have to do a little bit more discovery, have some depositions, see a little bit more before we dismiss the case?
Your Honor, I understand that sentiment, but there is no discovery in the world that's going to make a restaurant that has an online platform delivery contract responsible for an electric bicyclist deliverer by Grubhub. There's
Counsel,
no
we
cause of
don't know
action.
that
know why
on
you
this
say
record.
that.
I mean, you just made a statement that seemed to be as if you were making a statement as a matter of law that's completely not supported by law and is way beyond the scope of where we are at the context of this motion.
I think, Your Honor,
And what we're evaluating here, essentially, is the pleading in the complaint. And you're asking us to look at that in the context of a contract which occurred a year later. I think it's pretty clear that we're not very willing to do that.
I understand that, Your Honor.
So given that we're not, assuming that we're not willing to look at the year later contract, what is there in the record apart from affidavits which are not appropriate at this point, since
The year later contract,
all they do is raise questions of fact?
the year later contract is just the contract between the restaurant and
Counsel,
Grubhub.
assume that we're not going to consider that contract.
No,
And assume that we're not going to consider affidavits which contradict what's in the complaint. What's left for us to consider?
There is the Campiori agreement, Your Honor, which was dated in the right time and did govern his relationship, and there is the evidence.
Although there are cases that say that a contract like that doesn't necessarily govern whether they're truly an independent contractor or not, or whether they're an employee of Grubhub or otherwise. So we get back to the original concept here. Maybe this was just premature. Thank you for your argument.
Your Honors, may it please the court, Brian Isaac. I am prepared to rest on my brief if the court has no questions. I do want to point out one thing, though, with respect to the agreement between Grubhub and the restaurant. My adversary didn't even attach that on his case in chief. That was Grubhub who attached it. So you can't move the summary judgment.
But in a certain way, astonishingly, Grubhub and the restaurant are aligned on the issue of the bicyclist status. He belongs to nobody but himself, right?
That would,
right.
I would assume that would be their claim
Yeah.
at the time of trial, but I would point out to you is,
Right, which is why the fact that they happen to agree and nobody disputes it is not very meaningful on this motion.
I agree. And I'd also point out one other fact that Grubhub didn't appeal. They could have appealed too, they did not.
Know. Right.
Thanks for listening to me.
Yeah, thank you. All right, you do have some rebuttal. Go ahead.
I'd just like to reiterate that the documentary evidence on the motions, because there was a surreply and a surreply, the plaintiff's opposition was both to our motion and the cross motion. There were two contracts. It's not just the contract between the restaurant and Grubhub, it's also the Campiori delivery partner agreement, and the evidence that was submitted is clear that the facts in the complaint are incorrect. Mr. Campiori was never employed, he just merely picked up the food at the restaurant. And I understand the sentiment that discovery needs to proceed, and that is the response of the respondent, but when looking at the totality of all the documentary evidence and looking at whether there was a cause of action under these circumstances, I think the court below should have granted the motion to dismiss.
Counsel, I just have a question, because we're talking about the partner agreement. We know it's 2018, but what evidence was there that it was even in effect at the time of the incident?
There is the affidavit of Matthew Levine, and there is the affidavit of Mr. Marsh. Both agree that that agreement was in effect, even though it was dated, that governed the terms of their relationship.
I want to follow up. Now, this Campiori and Grubhub. Now, wasn't it a fact that he wasn't precluded from working for other restaurants, including Grubhub's competitors?
Sure, but we don't believe that that makes a difference as far as the absence of his relationship with the restaurant itself. That goes to whether he's a direct employee or an independent contractor of Grubhub. But he had no relationship whatsoever to the restaurant other than picking up the food. The restaurant was not aware of who picked up the food, when they picked up the food, how it would be delivered, when it would be delivered. All they have is an arrangement with Grubhub online that says someone at some point is going to pick up and make a delivery, and there's no law that supports a cause of action under those circumstances.
Thank you.
Thank you.
Cologne versus 5/160th. You can proceed, sir.
Thank you, Your Honors. May it please the Court, Robert Brigantic from the law offices of Michael Swimmer for Appellant R.B. Mart, Inc. I'll get right to it. What you have before you today is a conditional grant of summary judgment on a contractual indemnification claim that's on appeal, and you have a second issue, which is the discovery issue. And the discovery issue is absolutely critical to getting the decision right on the contractual indemnification issue. And I would point out to Your Honors that the discovery issue is unquestionably the product of plain error on the motion judge. The motion judge said he refused to order the landlord to produce its property management agreement, which we believe will show that the landlord retained through its property manager the responsibility for maintaining and repairing the sidewalk. And the motion
Well,
judge.
we have to look at the lease, right? The lease between your client and the landlord. That's the
Well,
primary
no,
document.
No, Your Honor.
No, it's not the
but
primary
it's both.
document?
It's both, because Article 9 of the lease imposes the obligation to repair and maintain the sidewalk on the landlord because it's a common premise, it's part of the common areas, and Article 10 of the lease imposes that obligation ostensibly on the tenant.
I don't know what you mean by
Deposition,
ostensibly. It seems to me Section 10.3 is very clear, and as a more specific provision would overcome paragraph 9.
But the property manager took that, but when granting conditional summary judgment, the court held that the landlord offloaded this responsibility to the tenant, but we know that there is a property management agreement in effect. Counsel has it for the respondent. They didn't produce it, and the motion judge said that we were not entitled to it because it's a demand subject to post-NOI discovery requests.
Note of issue.
Right.
Yes, that's wrong. We served the discovery demand 7 months before the
And what'd you do to enforce that demand? Weren't there conferences, and did you say, we didn't get this, Judge, it's outstanding? Did you move to vacate the note of issue?
Yes, we did. Before, we wrote to the respondent, and we said, produce it, and they turned around and moved to summary judgment. At the compliance conference, we said discovery was complete in the sense that we don't need new discovery.
But you never
we
moved
needed the discovery we had to have, we already requested, and which the court, if I may finish the answer.
Just finish the sentence, and we'll look at the record to see when you requested that discovery.
Yes, it's 7 months before.
Okay, thank you.
Thank you, Your Honor.
People versus Donald Lee.
What about,
You may proceed.
Thank you, Your Honors. Good morning. My name is Elizabeth Caldwell, and I represent Mr. Donald Lee. May it please the Court. The Court deprived Mr. Lee of due process when it repeatedly refused to pause the proceedings to assess his competence, both to stand trial and to give up his fundamental right to be present. Mr. Lee has suffered from a serious mental illness for many years. In his early 20s, he began having auditory hallucinations, and those symptoms progressed, leading to repeated hospitalizations.
We're aware, I mean, he does have certainly a history of mental illness, but in October, the court had declared him competent after an evaluation by 2 psychiatrists. The trial then happened, we're talking 5 months later, something about that. And then the court had Mr. Lee in front of him for some period of time where he was observing him. And the issue came up, he had an outburst. Should he be, there was a request for him to be evaluated, correct?
That's right.
And the standard is an abuse of discretion, correct?
That's right, Your Honor. But
so, okay, so let's work from there and say what at that time was happening such that it was an abuse of discretion for the court to not grant that 7:30 exam mid-trial.
Yes, Your Honor. So I will point out that the court had just received this case for trial. He actually consulted with another judge about what plea offer was appropriate because he had just become familiar with Mr. Lee and he was not the judge at the time of the earlier incompetency finding and then subsequent competency finding. In terms of what was happening in the trial itself, Mr. Lee was removed from court. His counsel later talked with Mr. Lee, and he came back to court and at that point reported, again, I think that a new exam is necessary because Mr. Lee is experiencing many of the same symptoms that characterized, symptoms of his schizophrenia that had earlier been found on the record when he was found incompetent. So he's hearing voices in the courtroom, he is experiencing extreme paranoia, he thinks people are laughing at him in the courtroom, and counsel explained all of this and also explained why he believed this was happening at this moment. There were several things that happened in the course of trial that seemed to trigger Mr. Lee's new symptoms, and at the same time, counsel said, Mr. Lee's also reporting to me that he's not getting his medication. And Mr. Lee was immediately put on suicide watch and given medical attention based on the courts, after the court heard that. So we have a record here that shows that medication was essential for managing Mr. Lee's.
Was there any renewed request for a 7:30 exam at the end of trial? If this was such a big issue and the judge kept hinting that he would consider it post-trial if necessary, did counsel ever make a request at the conclusion of the trial and say, hey, we need a 7:30 now?
There's no renewal on the record.
Why then should we consider it, if he didn't consider it important enough at the end of trial, to renew the request?
Yes, Your Honor. The fact that there's no renewal doesn't undermine the very genuine, credible, and detailed pieces of information that counsel brought to the court's attention. There was a week that passed.
During the course of the trial, after that outburst, which would indicate that this was an issue again, was there any other behavior by him or anything that was outwardly indicated that would show continuing need for a 7:30 exam?
So, as I said, counsel did relay additional things aside from that outburst, including that he was having auditory hallucinations and that he was unable to be rationalized with. So counsel has that report, and we have case law saying the counsel is in the best position to assess whether a new exam is necessary. In terms of the lack of renewal at the end of trial, I would point out that the verdict was a week later. It wasn't clear how long it would take for a new exam to be done if it was not on an emergency basis, as counsel had requested during the trial. And the record shows that Mr. Lee's mental status was very dynamic. There was an instance shortly after he was arrested while on Rikers Island where Mr. Lee reported that he was hearing voices, he was aggressive and anxious, he was put on suicide watch, given medication, and a day later, the records in his psychiatric records show that at that point, he was experiencing no more psychotic phenomenon and he no longer seemed to be in distress. So this is someone who has a very dynamic mental illness for which medication is essential, and we have here a record that shows he got medication after this outburst, after counsel reported these concerns to the court.
Just a question, because at the time the judge was evaluating it, and granted it was a new judge, but there was a lot of discussion where the defendant was participating in the question about whether he should or should not accept a plea before the trial started. And the judge seemed in part to base his determination on the fact that the defendant was actively participating in that conversation and therefore had the competency to otherwise understand the proceedings that were going on.
I would say that Mr. Lee was participating in some plea colloquy. He expressed interest in pleading guilty, but even those statements were, at some point he grew upset that he could not simply plead to the statutory minimum. He didn't understand that he had forgone that right. And if I may answer one more thing, the psychiatric evaluations, when Mr. Lee was initially found incompetent, during those evaluations, the evaluator said, he seems to understand what courtroom personnel are, he knows what a guilty plea is. The problem was that his way of thinking was so hindered by his paranoia, the other things that were phenomenon of his schizophrenia, that I think that the court may have thought, look, this person seems to be able to have a colloquy, but that didn't really go to the heart of what was troubling for Mr. Lee, and that counsel later explained to him, which is that he was hearing voices, he has this, he has a serious mental illness that was hindering his ability to be rationalized with, and that was a violation of his fundamental right to be tried only when competent. And if I may address the excessive sentence point,
I'm going to let you address it on rebuttal.
Yes, thank you, Your Honor.
Okay, thank you.
May it please the court, Andrew Seawald for the people. Good morning, Your Honors. Your Honors have put your finger on the applicable standard here, which is abuse of discretion, whether Justice Dwyer properly exercised his discretion in denying this mid-trial request for a new competency examination. And I submit that under all of the facts, he properly exercised that discretion. I would point out that by the time the request was made, the case had actually been in front of Justice Dwyer for several days. It had first come to Justice Dwyer on March 5th, when he held a fairly lengthy discussion with the parties about certain evidentiary issues and other pretrial matters. And then the case was adjourned to March 14th. That was the date that the judge gave the defendant Parker warnings. They went through antimarchy. The defendant seemed to understand that his lawyer would be representing him at sidebars during jury selection, and the counsel did not raise any issue about competency on that day. And then the next day, they concluded jury selection. The defendant asked about a plea. The court said it would keep the 11-year offer open over the weekend, going to the following Monday. Again, the defense attorney did not raise any issue about competency. So that's 3 court days that the defendant was in front of Justice Dwyer, and the defense
I respect that, but let me ask you a question. I mean, the man clearly had mental illness. Nobody's going to dispute that, right? It was diagnosed.
Sure.
Right, and we know, or I think we know, that in certain mental illness that the level of competency is labile, it's variable, correct?
You know, it's hard for me to talk about that. I mean,
well, we know it from this point, right? And we know it in this way. We do those 730 exams. People are found incompetent, and then they're given some treatment, and then they're competent. And then sometimes we see a cycle where they're competent and incompetent, competent, incompetent. So even if, let's assume Judge Dwyer saw him and he seemed to be functioning in a way that conveyed to Judge Dwyer that he was competent, did anything happen immediately prior to the application for the 730 exam mid-trial that would have alerted him or made him aware that maybe this man had decomposed?
I don't think so, Your Honor. And I would point out that on Thursday, March 15th, the judge has this discussion with the parties about the 11-year offer, and defendant was clearly interested in pleading guilty, or at least exploring that possibility. Then the case gets adjourned over the weekend. They don't meet on Friday. Case gets adjourned over the weekend. They come back to court on Monday, and on Monday, the defense attorney reports that he'd had extensive discussions with the defendant over the weekend, and that against the defense attorney's own advice, it seems the defendant wanted to plead guilty. But the fact that he had those extensive discussions with the defendant over the weekend proceeding, and then comes into court on Monday morning and is ready to have the defendant plead guilty, I think is very telling about what the defendant's state of mind and what the or competency was as of Monday morning. And it's also very telling what defense counsel's own view of defendant's competency was as of Monday morning. And it's only when the plea falls apart, and by the way, any mention that the defendant made about hearing voices referred to hearing voices at the time of the incident, not presently as he sat in court. And even when he mentioned hearing voices, defense counsel didn't at that point say, "Judge, I think he's hearing voices right now. I think we have a question about competency." Instead, the defense counsel tried to actually have the plea go through. And it was only when you had the complainant testify, and it was clear that the complainant had showed up to court, which apparently was not the easiest thing for the complainant to even appear. The complainant shows up. It's obvious that the case is going forward against the defendant. Defendant then again raises the possibility of a plea, and he's upset that he can't get a promise of a lenient sentence. And then he has this outburst and blames his attorney for not letting him plead guilty earlier. And even that outburst showed that the defendant was well aware of what his own attorney's role was. And it also showed some awareness that he was recognizing the reality of the proceedings against him. So I would submit that all of that went into Justice Dwyer's view that this defendant was competent, and that, or at least that he wasn't obligated to grant to order the examination simply because defense counsel had requested it. So for all those reasons, I ask the court to affirm.
Thank you. All right. Rebuttal?
Yes, thank you, Your Honors. With respect to the report about Mr. Lee hearing voices, Mr. Lee made reference himself to the fact that he was hearing voices at the time of the offense. That was a separate matter from what counsel brought to the court's attention later, when he said that Mr. Lee was hearing voices in the courtroom, experiencing extreme paranoia in the courtroom, and that was consistent with a statement Mr. Lee had made on the record saying, "Oh, it's funny," suggesting he was hearing those things as he was talking to the court. At that point, the court, when counsel explained that Mr. Lee was hearing voices presently, the court said, "This sounds like an insanity defense," only for counsel to say, "No, Your Honor, I'm talking about right now. When I've talked to Mr. Lee in the back, he seems to be hearing voices." So just to clarify that. In terms of counsel's extensive discussions over the weekend, counsel did say, "I talked to Mr. Lee today and previously about his options here," and he supported the decision to plead guilty initially, but that was before some of these triggering events, if we'll call them that, happened. So I think that we have here a defense counsel who was being candid with the court. He was trying to explain his concerns, and he'd established himself as someone who he had represented Mr. Lee for 2 years. He had never asked for an exam that did not result in a finding of incompetence. He had moved to confirm the finding of competence when Mr. Lee was found to be competent earlier. So I think this is someone who was familiar with Mr. Lee, and he was expressing genuine concerns to the court. And finally, I would say, with respect to the court itself, initially the court expressed some skepticism about the request, but as counsel came to him with more and more specific information, The court was not doubting counsel's reports or expressing concern about the veracity of what he was saying. I mean, what he was reporting was completely consistent with his symptoms of schizophrenia. The court said, I'm not assuming he's competent, I will give you this exam. He's essentially acknowledging that there's some basis to doubt Mr. Lee's competence, but he was very concerned with the efficiency of the trial to the point that he would not take a 2-day delay to pause the proceedings and assess whether Mr. Lee was competent, and that was a violation of Mr. Lee's fundamental right.
Thank you.
Thank you, Your Honors.
Thank you both. Kinstry versus United Coach Lines.
Good morning. May it please the court. Heather Ragone from Gallo Vitucci Clark for the appellants, United Coach Lines, and driver Valerie Zubov. The pedestrian in this case voluntarily placed herself in a position of peril unbeknownst to the defendant. Her actions, while obviously unfortunate, were the sole proximate cause of the accident and her demise. There are no bona fide issues of fact.
Why isn't there a factual issue, as was found below, in that the sister's testimony about where the decedent was standing at the time of the accident was different than the testimony of the driver, and put her standing by the driver's side right prior to the incident, which would change the sight lines and make the expert witness of the defendant inapplicable if that was true. So how can we decide as a matter of law to disregard her testimony, which clearly was inconsistent?
Well, as an initial matter, I think she undermines her own testimony. She tells the police her sister crossed between buses, and then she says in an affidavit subsequently her sister did not walk out of buses. So her own self-serving statements defeat her own purpose. That said, the defense experts did consider that the pedestrian might have been standing one step beyond the bus at the driver's side corner. At page 749 of the record, you'll see that a mannequin was placed in that spot at the correct height. And at page 750, you can see that
You say correct
mannequin's not
height.
visible.
What height?
Yeah, so
What's the correct height? Because I think there's an issue of fact in this record about the height of the deceased.
okay, I respectfully disagree. The pedestrian's height in the passport, which was the first document located after the accident, had 5'5".
Right.
I can tell you I'm a lot taller in my passport than I might actually be. We relied on the autopsy, which was contemporaneously, objectively measured her height.
Well,
at the time of
you're
the
telling me that autopsies, they don't necessarily make a mistake in measuring height?
I think
you
it's
have
much more.
something that, like a passport, where somebody self-reports the height that the woman didn't know her own height?
Well,
I just don't understand why, just because the autopsy says it, we can't contest that.
And to go to further that, there were there was testimony here that whatever hairstyle she had, that her hair was up like at 3 inches. So even if she really did measure 5'1" at the autopsy, that she may have been closer to the 5'3" or 5'4" because of her hair height, which would have at least, we're talking about what could be seen. So there aren't questions of fact here, not to mention the experts, somewhat disagreeing about things.
Well, if I may, on the issue of height, plaintiff's expert puts a 5'9" subject in front of the bus and takes a picture. I think that's disingenuous, not an issue of
I
fact.
don't know if it's disingenuous, but we still don't know really how tall she was. I might add that autopsies, depending upon whether rigor mortis has set in and to what extent, will change height,
If I may, the independent witness, Nan Mead, observed the pedestrian right with hands against the bus right before it started moving and said that the pedestrian was lower than the windshield, which would place her in the 5'1" category.
So all this means is that you have a good position going to trial. Where I'm having a problem is, why does this make this summary judgment material? Not that you're not making good arguments. If I looked at your arguments, I'm like, yeah, these are really good arguments. Why not to a jury?
Because again, the autopsy is, it's handled by a medical doctor who objectively measures the body. Now, I understand plaintiff has argued that the
Are you
injuries
taking the
mangled the body.
position that we have to always conclude that anything a doctor says is true, regardless of what else is in the record?
I think it's more.
Doesn't that classically create a question of fact?
I think
If
it's
a
more
doctor
competent.
says one thing and then another person observing it sees someone different?
I don't see why the passport would be more reliable where it's just subjectively reported by the person holding it.
It doesn't have to be more reliable, it just has to create an issue of fact. I think we're getting really boxed up in what we're looking at here in terms of the standard on summary judgment. That's really it. Is there an issue of fact? We don't have a definitive fact about how tall she was at the time of accident.
But it's also uncontested that she walked out mid-block without a crosswalk into the path of a vehicle, which is negligence per se.
Didn't the sister, didn't actually, I'm not sure that's uncontested, because I thought that the sister said she was waiting to look for the green bus, and she was standing there for a while, and I thought that the driver said he couldn't remember if he saw her there before. I mean, the way I read it, there were a lot of facts that seemed to be
Let me just respond on that. The sister then testified, and then affirmed in her affidavit her sister did not walk out between buses, which again, it's a self-serving statement.
Well, everything is self-serving, when people make affidavits. That doesn't mean it's untrue.
It's directly contradicting her what she told the police at the scene of the accident.
Counsel, I just want to ask one question. I got permission from Justice Gish. How do you account for the fact that the experts disagreed as to whether or not the convex mirrors could be adjusted? There was disagreement on that.
Because yet again, if the inspection of the bus had been done by plaintiff's expert, he would see that they are fixed and they are more than 9 or 10 feet off the ground. They're fixed. They're not intended for the purpose that plaintiff's expert has asserted. They're that high to provide a clear view for the driver ahead, and they're intended to show cars to the sides of the buses as they're driving. They're not intended to show in front of the bus.
Yeah, it's fascinating to me, although it's not part of this case, that there are blind spots immediately in front of a bus. But okay, let's hear from your adversary.
Good morning, Your Honors. Arnold D. Joseph for the plaintiff respondent. Not only are there questions of fact, but if you look at their expert's affidavit, his initial affidavit, he says the bus travels 10 to 15 feet at 1 mile per hour. Amazingly, in his supplemental affidavit, in order to try and explain away how the decedent was running diagonally away from the bus when the bus was coming at her, he increases the speed of the bus to 3 miles an hour in order to cover the distance and explain it away. Last year, in July, I argued one case, not July, right before the summer when you were arguing here, I got a case called Goldwire. Defendant's expert did the exact same thing. Ignored the sister's testimony, like in this case, ignored a witness testimony, and changed the speeds of the vehicle in order to reach a conclusion they wanted to reach. They're acting like jurors. They're taking whatever facts they want and then changing them around to reach a conclusion. That's the jury's function, not the expert's function. So in this case, they want you to change the height. They want you to change the speed of the bus. They want you to ignore how long the sister says, 2 to 5 minutes, that the woman was standing out in front of the bus. Just, we'll put our head in the sand, no questions of fact, we'll believe everything they say, and we're all done, and that's the end of it. But that's not what happens in summary judgment. And and the court was all over this on that aspect, but I think at the end of the day, when you have an expert that comes in one affidavit and says it was 1 mile an hour, and then in his next affidavit changes it to say 3 miles an hour, that is a question of fact. That's a jury question now. And unless the court has any other questions. Thank you.
All right, rebuttal.
Your Honors, there are issues that have been put before this court by plaintiff's expert that are simply red herrings and irrelevant to the inquiry into summary judgment.
He talks about the lawful nature of the bus's location. The NYPD agreed it was a lawful location. The signage at the location showed that it was lawful. He talks about the position of the bus being the proximate cause of the accident. So if we're going to talk about experts here, I think that plaintiff's expert has no basis, and I think the entirety of his report is incompetent evidence. The hopping case dictates that a position of a bus, if anything, might have motivated this pedestrian to enter the roadway, but certainly did not cause the accident. He speculates, Mr. Fisher, that this bus driver didn't use his mirrors, that he didn't pay attention. The driver had been asked in context, did you pay attention to the pedestrians on the sidewalk? And he said no. He said that he looked in his mirrors, he looked at his gauges, and he looked at out his window, and he saw no one. This pedestrian was placed by 2 eyewitnesses immediately in front of the bus, touching the bus, as they described, as though it was trying to hold back the bus. She was that close. She hadn't given no warning of her presence in the roadway. She shouldn't have been there. There were crosswalks half a block away in each direction. Even applying the noseworthy standard, which plaintiff has mentioned, it doesn't relieve plaintiff of their obligation to provide evidence of negligence. There is none. No one said that this driver saw her, or obviously he wouldn't have proceeded forward. She shouldn't have been out in the roadway. Thank you.
Thank you. Thank you both. Sqn Asset versus Shunfang.
Good morning, Your Honors. May it please the court. I'm John Malieri, an attorney for the defendant appellant Shunfang International Clean Energy. As I'm sure the court is well aware, this is a case about a lender seeking to maximize collateral to a value above its loan while also seeking funds from a guarantor that will ultimately reap a massive windfall. We believe that the bankruptcy plan in which Sqn granted a release
Can I
to...
ask you a question, and I really don't know the answer to this question. Does the possibility that in the future the lender might get more of a recovery against the debtor based on the agreements it entered into preclude it from moving forward to recover on the guarantee until a final determination is made at some point in the future as to whether it will actually receive those benefits?
The answer is the trial court made 2 decisions in that regard. One is they have to account for it now if it's commercially reasonable to account for it now. The trial court, based on absolutely nothing in the record, said it was not commercially reasonable to account for it now, even though we know from testimony from the debtor and from the lender that there's a liquidated sum we could attach to it.
Let me ask you a question more specifically then, as applied to this facts as opposed to more theoretically. One of the big issues we don't yet know is whether Suniva will ever receive anything from the AC/CVD claims. It might not, it hasn't yet. Do we have to keep open any claim against the guarantor until a determination is ultimately made whether or not amounts will be received to ultimately make that determination about the offset? At what point do we say no funds have been received, we're going to close that book at this point? I know there are other issues too, but just as to that issue.
Yes, Your Honor, the answer is either the judgment needed to say we would get the surplus if a surplus occurred later. If the trial court is going to grant summary judgment.
Meaning you'd get that, I've never heard of that as a solution. You'd get the surplus if and when there ever was a surplus?
The UCC requires it. After they've recovered their loan amount plus any other sums that are due, the UCC says the surplus has to come back to us. That's what the UCC requires. But the court...
But there is no surplus yet as far as...
Correct. So the judgment here, the court says you're not entitled to the ADCVD claim. So the court has made a decision that we're not entitled to them. That's, we contend, reversible. And if the court was going to grant a judgment to Sqn, it needs to reserve the possibility that the surplus be paid back to us. And Your Honor, again, it should have, the trial court should have, if it was going to grant judgment now required that the amount of the AD/CVD claims be credited because it's commercially reasonable to do so. The court found it was not commercially reasonable, even though there's a liquidated sum we can attach to it.
It made a fact,
No, go finish.
It made a fact-finding determination, you're saying, that they would never be received, and there wasn't a basis in the record.
That's
for
correct,
trial
Your
court
Honor.
To do that.
That's correct.
So, and I'm going to ask you about those claims also. Are they the same as the trade case claims?
The trade case and the AD/CVD claims are related, but no, the AD/CVD claims are the sort of fund created by the president's order that tariffs will be placed on foreign
So
imported.
that was the settlement funds.
Correct.
Right, and I read I believe in your papers, and I'm not sure that I saw that the other side agreed. Was that part of the collateral that was held for the loans?
By their own admission, it is. They moved the bankruptcy court and said, for the avoidance of doubt, we claim a pre-petition security interest in the AD/CVD settlement proceeds. And then the bankruptcy court, in granting stay relief that allowed them to conduct the equipment auction,
Which was only partial
exactly.
collateral.
Exactly.
And you got a credit for that collateral, although you dispute whether you got an
Correct.
appropriate credit. But even apart from that, you believe that you were entitled to an offset for the value of the collateral in those, in that trade case settlement.
That's correct, Your Honor.
And what, was that value ascertainable at the time? At some point, it was converted. In the bankruptcy court, the plaintiff gave up its right to that collateral.
That's correct.
Was a value placed on it? Do we know what it was worth? Did they give it up because it was worthless? Or?
There's a schedule in the equipment lease, which is where the provision for payment of these AD/CVD claims back to SQN exists. And the schedule says if Suniva gets X dollars, we get Y dollars. And both Suniva's witness and SQN's witness testified that at a minimum, the AD/CVD settlement would be $150 million. And according to the settlement, that would yield $22 million for SQN. So it's readily ascertainable.
So let's say there already had been a recovery on the AD/CVD claims. Is there a dispute that if there had been some recovery in that, whether or not you would be entitled to an offset for that? Is
Yes.
the opposing counsel still disputing that there would ever be an offset for those amounts?
I believe so, because now they're saying two things, as I understand it. One is the bankruptcy court never actually made a ruling that the AD/CVD claims were collateral, so we're not bound by the position we took in the bankruptcy court that they were collateral. That's number one. And number two, they're saying, well, because of this scheme we entered into where we got the AD/CVD claims paid as equipment leasing money, you've already been credited for these AD/CVD claims because we foreclose on the equipment. So that's really the crux of this case.
No money was received for when that foreclosed. They bought the first half of the collateral.
Correct.
And you got a credit for that. But as for
Definitely.
the second half, you never got any tangible credit for that amount.
That's
Is that
correct, Your Honor. That's absolutely right.
Whatever happened to it, it went into either it went into potential claims. You never received any offset for that second half of the collateral.
That's correct. So the lender made a $50 million loan and stands to make upwards of $75 million. And they're trying to say to this court, you don't need to give the guarantor any of that money, even if they pay on the guarantee. We're the ones who should make that windfall. But the UCC says it should come back to us after they're made whole.
But none of that has happened yet.
That's correct, Your Honor.
Okay.
Moreover, of course, I'm sure the court is well aware, we also contend that the disposition itself was not commercially reasonable. The trial court it conducted a trial, essentially, and found that the Dalbin spec post hoc valuation was credible, that the credit bid that that SQN made was for the right amount, that our expert didn't give competent testimony and theirs
Right,
did.
and that was assuming that the notice was not compliant.
Even if the notice, I'm sorry.
So, right, and I'm just saying that we went right to the heart of the issue about whether they proved commercial reasonableness.
Your Honor, just to
Okay.
be clear, and I know that my time is up, the sale needed to be commercially reasonable no matter what. The lack of the notice
Had a
made
presumption
presumption
effect.
that it was not
Yes.
commercially reasonable.
Yeah, we're aware. Thank you. Thank you.
Good morning, Christopher Haupt of Mayor Brown. With the court's permission, I'd like to introduce my colleague Michael Lindinger of the Bar of Illinois and Washington, D.C. to argue for SQN.
All right, thank you. We're so introduced.
Good morning, Your Honors. Michael Lindinger, Mayor Brown for SQN. Our briefs.
Let me ask you the counterpoint of some of the questions I was asking opposing counsel.
Yes, Your Honor.
Why wouldn't the guarantor be entitled to an offset for the potential amounts to be received from the AC CVD claims? And if it's really true that nothing is to be received, then an assignment of them. So if they are received, there won't be a double recovery by the lender.
So, Your Honor, at no point are we double dipping here.
Sorry, what?
At no point are we double dipping, Your Honor.
Not yet.
Nor into the future, Your Honor. We credited Shunfang this $25 million credit bid from the auction.
You credited them for the auction. If you win this case, you're going to get made fully whole by the payment of the guarantee for the remaining balance. Well, you're saying it's only 63%. Go ahead. Go ahead.
It's unclear, Your Honor. This is 9 years and going on that this has been waiting around. To say this is imminent or anything to that nature is beyond speculative. In fact, just a few months ago, the World Trade Organization sided with the United States for the former President Trump's more recent tariffs in 2018 regarding the solar industry. China responded in a press release calling that erroneous and dangerous.
But what happens if, we don't know the answer. What happens if you do eventually get a recovery? Won't you be getting a double dipping at that point?
No, Your Honor. The equipment lease was a separate agreement from any sort of settlement which resolved multiple litigations. It was not.
So then what happened, if the equipment lease is truly a separate agreement, what happened to the second half of the collateral? There was 4 lots of collateral. You purchased 2 of them. Your client purchased 2 of them and paid for them. What happened to the other 2 lots of collateral? They just disappeared into the air? Isn't that what became the basis for the equipment lease?
No, Your Honor. There were 4 lots at the auction, 2 of which were bid on by Wang Chung, a separate entity. The AD/CVD claims were not part of the auction at all.
Right, but that brings us to the point. They were part of the collateral given for the original loan, weren't they?
There were certain statements made in the bankruptcy court proceeding represented to the bankruptcy court. We were not involved in that, but
Yeah, that doesn't matter. Were they collateral or were they not?
it appears they may be. That said, the bankruptcy.
So assuming that they are, don't they have value, and isn't the guarantor entitled to an offset for whatever the value is of that collateral, which was not subject to the auction? It's still collateral, whatever its value may be, and we may differ about the point of time that we have to figure out what the value is, but isn't that a crucial issue that needs to be decided?
We believe the trial court decided it correctly. The fact that
It left something open because it basically said, well, we haven't recovered anything yet from the AC/CVD claim, so we're not going to give it any value. But how can the court make that determination that it has no value just because nothing has been recovered yet?
we were under the, we were responding, and the trial court evaluated appellant's argument under the accounting argument, the section 9(615) of the UCC. And it's only an accounting if it's commercially reasonable to do so. There's been no disposition. There's been no amount settled upon. There's been no settlement. There's been nothing. So there's nothing to account for. It's again, highly speculative is to be kind. 9-615 states that there is an accounting if it's commercially reasonable to do so. There's nothing to account for here.
If your client didn't think it had value, why did it build it into the equipment lease?
Your Honor, the equipment lease was, again, entered into the settlement agreement, and then the equipment lease separately was entered into in the fall of 2018, roughly 6 months or so after the auction. Sqn wanted to get the equipment going again. They wanted to help the industry.
No, I understand, but you made the trade claims part of that, didn't you?
There's reference to them in the agreements, but the equipment
So
leases.
that would be yes, right? Why would you even include it if you didn't think it had any value?
Again, I don't think SQN has ever said the value is zero. I believe there's testimony in the record that Mr. Modak stated that there's never been an indication that the value is
So
zero.
why shouldn't there be an offset? Since those only came because of the original right and security interest in the collateral. There's no question that the security interest in the collateral is what gave you the leverage to bargain and get a settlement agreement that ultimately gave you the rights to those proceeds. So why wouldn't, again, that be an offset to payment since it was based on your initial right to the collateral?
There would be no offset at this time, Your Honor. If there is any sort of determination as far as the value of
If we
that.
upheld the order as it's now provided, there would never be a right because that would be the end of it.
No, Your Honor, the court never, first off, I wanted to address that point that my
And I'm going to let
opposing.
you answer that particular point and another question. Obviously, we have a lot of questions about this case. Go ahead.
Okay, Your Honor.
Finish.
So I did want to address that relates to something my opposing counsel said. The court never ruled in its decision that SQN couldn't ever, I'm sorry, that Shunfang could never get ADCVD claims.
I think it did rule that.
I
mean, that's the clear. Let me ask you the other question, though, which is as to the foreclosure sale. The court clearly said, okay, there's a rebuttable presumption, notice was not provided properly. So then you have to rebut that. In this case, both sides clearly submitted conflicting evidence, conflicting expert opinions. How could the court then make those credibility determinations that one was correct and one was incorrect and decide as a matter of law rather than giving that issue to try a fact to ultimately make that determination?
Well, in a bench trial, Your Honor, as this would be, I mean, the judge is ultimately the finder. What? This would ultimately be a bench trial.
This wasn't a bench trial, though, right? This was a dispositive motion.
It's a summary judgment motion, but
Right, so this was not a bench trial.
I know, ultimately, he would be the finder of fact.
So he could jump the gun and do it on a summary judgment motion rather than at the bench trial?
No, Your Honor, that's not what I'm saying either. This is not a traditional battle of the experts. Opposing counsel submitted a 2-page, very bare bones report. We noted on, in our brief, I believe it's record.
Let me just ask you, because we're really running out of time. You're saying that the trial judge made no assessment of the competing evidence and reached the conclusion that their evidence just wasn't that good?
It's not that their evidence wasn't good. It's completely speculative and conjecture. You cannot just submit an expert for the pure purpose of couching attorney argument to generate try to generate a genuine issue of fact. We had an appraisal expert with experience in the solar industry that his report was unrebutted, the methodology, the conclusions. They ignored the ubiquity evidence. They ignored their own subsidiary Suneva's valuation at the time. There's all sorts of supporting evidence that we rebutted the presumption as far as the value of the equipment, which was substantially more than all the other valuations as far as the credit bid, and that we conducted the auction itself in a commercially reasonable process. There's not a dispute as far as fact. Yes, we devoted some pages in our brief, but that's merely because their expert was trying to generate issues of fact when none exist. In fact, we rebut most of their arguments with their own experts' testimony supporting our case.
Okay,
Thank you.
Thank you. Rebuttal.
Counsel, I have a specific question in reference to something your opposing counsel just said. He said no accounting is required because there are no proceeds, and the only right that you would have under the UCC is in a right to accounting of proceeds that have actually been generated. What is incorrect about that argument?
That's incorrect because the UCC requires us to be provided and paid any surplus that occurs in the future. It only requires it to be accounted for today if it can be done so commercially reasonably. In other words, if we can reduce it to a liquidated sum now.
Which we can, obviously, because we don't know if and when there'll ever be any value, so what's wrong with this argument?
What's wrong with the argument is that, first of all, the trial court went off and made a factual finding that it's not commercially reasonable to liquidate it now, so that's something that should have been decided at a trial, but even
Well, does your expert say it was commercially reasonable to liquidate those claims now?
There's no evidence one way or the other, and it's their burden. Then the second thing that failed to happen is that as you pointed out, Your Honor, the trial court said not just that it can't be accounted for, but also went the second step and said we will not be entitled to it. Erroneously ruled it.
I know you're saying that, and when I read the decision, that was my impression of what he's saying. Your adversary said that's not true, that the court doesn't preclude you from getting money should they ever recover on those cases.
Well, although the trial court decision does say that there's nothing to value now, in the next paragraph it goes on to say that erroneously in our view, the equipment lease credit bid was all the consideration we will ever get for the ADCVD claims, disputing that it constitutes additional collateral.
Okay, all right.
Thank you, Your Honor.
Thank you. Thank you. Thank you both. MF 385 versus Colutes.
May it please the court. Good afternoon, Your Honors. I'm Theodore Mavromihalis of the Mavromihalis Law Firm, PC. I'm representing Mr. Nicholas Colutes, the appellate defendant on this case. Your Honor, I'm asking that the court reverse the lower court's decision, which did not allow my client to avail himself of the defense that the personal guarantee lacked consideration. This case involves an underlying lease agreement which was assigned.
But given that the guarantee said on its face that it was given for consideration and that there was ample email correspondence before that established that the guarantee was essential to granting the lease extension, what issue of fact was there?
Well, actually, Your Honor, there is an issue of fact because every lease, and especially in particular to commercial real estate agreements, that the lease is the letter of the law of the case. If the lease has specific assignment language in paragraph 18, nowhere in paragraph 18 does it require a replacement guarantor or a successive guarantor. In fact, the original tenant that had the lease—
Does the landlord have the right to reasonably withhold consent to?
No.
No,
The landlord-
it's no restrictions on it whatsoever. The tenant can assign, the landlord doesn't have to know, doesn't have to consent.
Of course the landlord has to know, but the test for whether or not an incoming tenant, which is the commercial tenant, not its principal or guarantor, is a permitted assignee, which is clearly defined in the lease agreement. There's 4 pages dedicated just to how we're going to assign this lease to a new tenant. You show me one place in this entire lease where it describes replacement guarantors. It doesn't. So on its face, the lease agreement which controls, there's issues of fact whether the lease agreement itself permits the landlord to require a replacement guarantor. Many leases have such language in them, but this, unfortunately, this lease did not. And the original guarantor, the original tenant, the original principal of the first tenant remained as a guarantor. So the other thing to consider, Your Honor, is that my client was seeking to get a written consent to this assignment for his entity. The landlord delayed several months and then sent an email acknowledging, allow this email to serve as written notice of acceptance.
I'm trying to understand what prevents the landlord from doing it. This is a commercial lease. Both the landlord and the tenant assigned the original lease, and this guarantee was given in consideration of plaintiffs consenting to the assignment. I mean, it makes sense that the landlord might not like to have the original guarantor continue on, since it's a different entity that now was assigned the lease. So I don't get what the issue.
The issue is the black letter law of the lease. There's a difference between the tenant, who's the corporate tenant coming in. This court has already held in 170 Mercer 17, I'm sorry, I don't, Moon 170 Mercer, that a party can avail itself of an unconditional guarantee and claim that there's no consideration. That defense is available to anybody signing a personal guarantee. The personal guarantee is a separate agreement. It doesn't count as part of the lease. It can be referred to in the lease, but here it wasn't. The only reference to the guarantee is that the original tenant principal shall remain as guarantor. So there is nothing in the lease, there's no requirement in the lease for my client to have been forced into a guarantee when he
I understand your argument. I actually have a notation here, but I don't have the lease. That in the record at page 105, there is a requirement that the landlord consent to assignment. Honestly, I don't have it in front of me, but I'm going to look at that because your recitation is not how I understood the lease. I may be wrong, but I'll take a look at it.
But well, the humor is, Your Honor, that...
But you'll allow us at least, if in fact the lease did require or did allow for the landlord to consent to the assignment, gave them that right, then there was consideration and you lose, right?
Well, actually, no, Your Honor, because it's still governed by the underlying lease. And if I could add that on 105, that was the second consent. The first consent was given by email. The second consent, which is referred to in 105, was presented almost a month after the transaction had taken place, after my client had already invested hundreds of thousands of dollars into this business, and then get surprised a month later, we need a guarantee from you now. They didn't show up at the closing. They had an opportunity to. They had an opportunity to terminate the lease.
That's just business, though,
Okay,
honestly.
but then
So
shouldn't
I'm
they
not.
sign it? Shouldn't they
Right.
sign
I'm going to
it?
look and see if in fact it was. No,
It wasn't even signed.
It doesn't.
I'm sorry, Your Honor.
You know, your client may have business gripes. That is not what we look at here. We're going to look at the lease. You're telling me the lease doesn't say what I think it says. I'm going to look and see. I'm going to ask your adversary if it says what you say. That's the key. The fact that your client put money into the place doesn't enter into it. I'm sorry, sir. Thank you.
Thank you, Your Honor.
Good afternoon, Your Honors. Meryl Biscone from the law firm of Rifkin Radler, and I represent the respondent here.
Okay,
Yes.
so here's the question. Did the lease give the landlord a right with respect to assignments?
Yes.
And what was that right in the lease?
Page 105, consent to assignment. And it's
What does it say? I'm
subject to the
baffled
terms
by
and
this,
conditions.
honestly.
Subject to the terms and conditions of this agreement, landlord hereby consents to the assignment of the lease by assignor to assignee and the assumption thereby by assignee.
Well, that is a consent, but where in the lease does it require that the landlord consent?
There's nothing in the lease that requires it. But it's our position that summary judgment was properly granted by the Supreme Court. The plaintiff established the three elements necessary for summary judgment premise on a guarantee: the unconditional guarantee, the underlying debt, and the failure to perform. No issues of fact were raised in that regard. The Supreme Court properly concluded.
So if the lease doesn't require consent, what do you make, how do you respond to your adversary's argument that the consents given have no consideration?
So it's our position that that defense just was not viable. The guarantee expressly, the guarantee expressly recites that consideration was given as an inducement for the execution of the lease. The cases cited in our brief indicate that in and of itself constitutes consideration.
That we wouldn't look beyond that.
There's no reason to look beyond that, right? The guarantee was specifically referenced, as Your Honor indicated, in emails, and the landlord indicated that he would not consent to this assignment, but for this guarantee. So finally, the guarantor's argument that the guarantee was somehow invalid because it wasn't executed at the same time.
Well, I suppose he could have made a business decision. We'll leave that aside. You know, not to sign the guarantee, and then they'd wind up in court hashing out whether it was required or not, right?
Right. So
Once he signed it, your position is he signed
signed
it, he's
and,
stuck with it.
right, there's no valid defense, and there's no issues of fact raised. That's our position. Thank you.
Okay. Okay, thank you both. Yeah? What page? Oh, okay. That's fine. Okay. Oh, I'll check the record. Environmental safety versus APS contracting. You may proceed.
Amanda McLaughlin for Appellant, New York City Housing Authority. For over 20 years, the courts have consistently upheld and strictly enforced NYCHA's contractual notice of claim provisions. Compliance is a condition precedent. Non-compliance warrants dismissal. This year alone, this court, in several cases, has addressed this exact issue and strictly upheld NYCHA's contractual notice of claim provision. In this case, the notice provision is Section 23 of the General Conditions. Section 23 required that when respondent APS had a claim for extra work, they were required to, within 20 days of that claim arising, provide NYCHA with written notice of intention to make a claim, and that notice needed to contain the nature and amount of the extra costs and damages and the basis of the claim.
So what starts the running of the 20 days?
So the start of the running of the 20 days is generally when they are given the direction to do the extra work or realize that something that they are going to do was not provided for in the contract. The court has also held that the time begins to run as soon as damages are ascertainable.
So now, but can't it sometimes take a while for damages to become ascertainable?
While that is possible, in this case, we're dealing with contractors. Contractors do bids before work has ever begun.
Yes.
They're able to price out entire 2-year construction contracts for 20
But obviously,
buildings.
they always get it wrong because there's always all these additional change orders and things. I mean, those are, you usually get more of that than the regular contract stuff. So, I mean, obviously, yes, you may price it out, but we know that it's not a guarantee what happens after that, right?
I think, yes, I think anyone familiar with contractors is not exactly getting it right the first time. But the court has held as soon as damages are ascertainable, not when the contractor actually ascertains the damages. And in this case, in a lot of these claims, the contractor had already filed change order requests, so they'd already ascertained their damages and done that calculation. And the notices in this case.
And the fact that there's discussion and you say, you allegedly may say, look, just wait, or we'll take care of it, that doesn't matter. They have to file those claims. That's like a, drop dead deadline. If they don't do it, they're out.
Yes, Your Honor. That has been consistently held by this court. Conversations afterwards, negotiations do not change when the claim arose and when the timer began to run. And so each of the notices that—
You, of course, have a no estoppel
Yes, Your Honor.
provision.
Section 62
Right.
is our no estoppel, no waiver, which has been upheld numerous times by this court. The documentary evidence in this case has shown that APS's notices were either untimely, failed to include damages, or both. Now, every element of the notice is independently required, as this court recently reconfirmed in Universal Construction Resources. And failure to meet these requirements means it's deemed to be a conclusive and binding determination that APS has no claim against NYCHA.
Counsel, notwithstanding the no estoppel provision, it appears that NYCHA employees frequently engage in negotiations with the contractor. Isn't that somewhat confusing and manipulative towards the contractor if your own employees start to engage in negotiations which they apparently have no authority to do?
By the time NYCHA employees are engaging in negotiations, the claim has already arisen. When they brought this claim to NYCHA, they should have already filed this notice. The negotiations would be happening afterwards if APS had done the process properly. And it's not a problem this court has held in numerous cases, such as SJ Fuel and high-tech construction, that negotiations do not impact the contract provision requiring notice within 20 days.
I'm gonna ask a little off-base question, and it's this. I mean, obviously, we always get the cases where the notice is not timely given, and we're confronted with that. I have to say, it seems like a real tough contractual provision to comply with. How often do contractors actually comply with this provision and get paid for the work that they legitimately do that's an appropriate change order? Just ballpark it for me.
I actually can't really answer that question. I've only been working for the Housing Authority for a few months, but I do know that we have numerous contractors that do this correctly. Actually, a frequently talked about topic.
Fair enough. Thank you. All right.
Thank you.
You may proceed, Counselor.
Good morning, Your Honors, and may it please the court. My name is Victor Rivera, and I represent APS Contracting here. I think Your Honors hit upon a point earlier on that was very interesting. The contract itself, I think, as we noted in our brief, contains a change order procedure. I mean, we talk about the contract, we talk about the procedures that are contained therein. One of the procedures contained in the contract is a procedure by which you are supposed to alert the NYCHA to extra work and work that is supposed to proceed, by which you are supposed to negotiate the contours of that work, and by which you are supposed to receive a decision on that work.
But isn't what the contract really requires that notice be in a very formal form?
Well, there is, in fact,
the NOIC, and that unless, if you don't send that form and you just start engaging in negotiations, what's going to happen is what happened here, which is you miss the 20 days. So I don't understand why, given the dozens of cases we've decided interpreting these provisions, most recently the APS contractors case from earlier this year, why it doesn't behoove lawyers advising these contractors, the first thing you do is send the notice, then you negotiate.
Well, you certainly end up with a sliding scale, I think, when you start talking about what the NYCHA is requiring. Because what they're essentially saying is that when you get some sort of a negative determination, you're supposed to let them know. So if I'm on the phone with the project manager and he tells me that we're not going to get something, then we should put them on a call. But in fact,
first get some more work. As soon as you get a call, hey, we want you to do this work, and your client says, hey, this is not on the contract, that second, you send in the notice of claim.
right. But there is a procedure, Your Honor, and I understand that, but there is a procedure, Your Honor, and it's built into the contract. And in fact, we have in the record, with respect to two of our notice of intent to claim, we have two letters that went through the process. They show what happens when you go through the process. And you have a letter in this instance, and these letters come from the appropriate NYCHA person who's designated within the contract. They are designated at the top of them as change order rejection letters. They have appropriate language at the end that says that you have Section 23 rights for a claim now. And so you have embedded in this contract already a procedure that talks about how work is supposed to go. It talks about how work is supposed to be negotiated. So when we talk about the negotiations, when we talk about the claims, when we talk about the change orders and how the process is supposed to go, what you have is a portion of the contract which my client was following, which essentially says that there's There's a change order procedure that you're supposed to follow here. And it's supposed to resolve itself with some sort of a communication from NYCHA through an authorized person. There's a person designated in the contract. And you know, you get something that tells you there's some sort of final resolution of it, and then you do this.
Wait, section 20, you're not really answering the question. Section 23 is pretty specific. It says, if you believe you get a request that involves a change of scope, you file the notice of claim, not after you negotiate and see whether they'll agree to it. As soon as you get something that you, contractor, believes, I mean, whether it's too strict or not, that's what it says. As soon as you get that request for something you believe is outside the scope, you send in a notice of claim.
Well, the question of belief, Your Honor, when you're in the midst of negotiations with NYCHA
Before
authority.
you start negotiating.
I'm sorry?
Before you start negotiating. I mean, it'd be one thing. There's been so many decisions that have keeps enforcing Section 23. So now there's not a shadow of a doubt. As soon as you get the request for something that you, contractor, believes is out of the scope, you send in a notice of claim before you start negotiating. Haven't we said that again and again?
But the change order process itself is a negotiation. It begins with you telling the agency that you have a discrepancy that you need to work
Why, at the same
out.
time you tell them you have the discrepancy, can't you as the attorney instruct all your clients, the second you decide there's a discrepancy, the second you see that it's outside the scope, that you send in a notice of claim the same time you begin the change order process simultaneously.
Among other things, Your Honor, among other things, Your Honor, at that point, without knowing what the conclusion of the negotiations would be, you would be hard pressed to figure out what your damages are. In this case, you have a situation where the contractor
Damages is the full course of whatever you believe is outside the scope of the work. If eventually you can't proceed, but you've put in your notice of claim. This is what it will cost me. This is what you're asking me to do outside the contract. This is what will cost me over and above the contract price. And if you're eventually successful, then you withdraw the notice of claim.
And those notice, and we believe, Your Honor, that the notices of intent to claim that we submitted were submitted at the times when we were able to submit all of that information in one form.
But the problem is that those were much later than 20 days after you were first aware that NYCHA wanted you to do something beyond the scope of the contract. And I think the question is what your timing is, and that what you're saying is when something happens, your clients begin to start negotiating. But before they start negotiating, they have to send the notice of claim. If in the notice of claim they make the wrong estimate of how much it's going to cost them, then that will be worked out later. But that's the moment when they have to send the notice. And it seems to me it's perfectly, I mean, it may be severe, but it's certainly clear in the contract. And we've interpreted it that way dozens of times.
Well, Your Honor, we believe that there should be a distinction between a change and a claim, particularly when there is already embedded in the contract a procedure that allows you to go through a negotiated process for the resolution of these extra work demands.
Thank you.
Thank you, Your Honors.
Will you rebuttal?
I just want to address this notice of claim versus change order issue.
Why isn't it enough to do the change order request? And is what you're really saying that at the same time any application is made for a change order that the contractor has to do a notice of claim at the same time?
The timing actually could be at a different point in time, but the reason that a change order request is not sufficient notice is that the notice provision is very specific. It has to identify itself as a notice of intention to make a claim. It has to include the basis of the claim, the nature and amount of the damages, and it has to be done in the right amount of time. Every element, even identifying it as a notice of intention to make a claim, is required.
So from my mind, my understanding of how you view the different provisions is that if you get a negative determination on a change order, that's what triggers the 20 days, right?
No, Your Honor.
Well, it's not at the time that they put in a change order. Does that trigger the 20 days?
The 20 days can be triggered even before a change order request is put in. It's triggered when they are able to ascertain their damages. And now that may just be at the
And
same time they put in that.
Not that you're going to deny the claim, just they know that they believe it's extra work.
Right, as soon as they think that they're doing extra work, that's when they have a claim. Whether we agree to pay it or not is not the issue. If we did as opposing APS wanted, and we waited until the denial of a change order request, then we would, if APS never submitted a change order request, their time would never begin to run. The time cannot be dependent on when APS chooses to submit a change order request.
Okay, thank you.
Thank you.
Thank you both. People versus Thompson. You may proceed, Counselor.
Good morning. May it please the court, Sunday Ramaswamy of Millbank for Mr. Thompson. This court should reverse the conviction because the trial court erroneously discharged 2 sworn jurors as grossly unqualified. Under CPL 270.35 Section 1, a juror is grossly unqualified when it becomes obvious that they possess a state of mind which would prevent the rendering of an impartial verdict. Here, the trial court discharged 2 jurors for per se violating its instructions to not discuss anything about the case. Such a general violation of instructions is not sufficient to show that the jurors were grossly unqualified. The trial court needed and failed to establish that the jurors were incapable of rendering an impartial verdict. The trial court explicitly and wrongly equated the jurors' general violation of its instructions to not discuss anything about the case with being grossly unqualified. On page 300 of the transcript, following defense counsel's objection, the trial court responds, "I understand it's over your objections, but they have violated my instructions. They both understood they were violating my instructions, therefore grossly unqualified." Here, the trial court has explicitly equated a general violations of its instructions with being grossly unqualified. Additionally, on page 300, the trial court even states that the jurors are grossly unqualified, they admitted violating my instructions about discussing the case earlier, and substantively, it's clear. Instead of evaluating whether the jurors had partial states of mind, the court focused exclusively on the jurors' discussion and the fact that it was a violation of its instructions. I'd like to direct this court to page 297 of the record. Instead of inquiring about Mr. Marks' state of mind, the trial court asks, "Did you not understand my instructions was you were not to be discussing anything about the case? Do you recall what I said about these instructions, specifically that instructions having to be followed in their letter and spirit?" Immediately after Mr. Marks said yes, the court decided to dismiss him as grossly unqualified. Similarly, the court...
It's your position that at that point the court should have inquired as to the juror's ability to decide the case and so on, fairly and so on.
Yes, in this case, the trial court didn't elicit any evidence showing that the jurors were incapable of remaining impartial following these discussions. The trial court didn't elicit any evidence of bias. In the past, the Court of Appeals has found evidence of bias to be a relationship with the witness of a business or intimate nature or something of the sort. But here, there was no evidence that the jurors could no longer remain impartial. Similarly, the court hinged its dismissal of the alternate juror on her violating its instructions, as just transcribed on page 299. The court asks, "Do you believe that you violated my instructions?" and excuses her immediately after she says, "I do." Here, the trial court has entertained a wrong view of the law by equating a general violation of its instructions to not discuss anything about the case with being grossly unqualified. Additionally, the jurors' discussions alone were not sufficient to dismiss them as grossly unqualified. Mr. Marks' entire inquiry can be found on pages 296 to 297 of the record. Mr. Marks only stated that he made some general comments about the witness and some of the testimony, but nothing specific. He further specified that he only commented on the demeanor of the witnesses, but not on the quality. As seen on pages 298 to 299, Ms. Tobin only stated that she and Mr. Mark had discussed how being a part of the trial was a fascinating process and they were privileged to be a part of it. She clearly expresses deference to the trial court here and a respect for the process. Such discussion does not amount to premature deliberations, as not all juror conversations constitute premature deliberations. For example, these courts have held that a venting of feelings do not constitute premature deliberations. And Mr. Marks and Ms. Tobin's conversation hardly amounts to even venting, let alone premature deliberations. While the jurors' discussions did not amount to premature deliberations, even...
Do we, if we find that it was premature deliberations, is that the end of the inquiry?
No,
Go on to the next step.
No, even if the jurors' discussions were found as premature deliberations...
Still find that they were not grossly disqualified.
Right, this would still not show that they were grossly unqualified to serve, exactly. Because the Court of Appeals holding in People v. Mejias is controlling here, in which it held that premature deliberations by itself do not render a juror grossly unqualified. A juror is only grossly unqualified when they are showed to be incapable of rendering an impartial verdict, or that they have closed their mind to the remaining evidence and have prematurely made a final judgment or prematurely formed...
In this case, there's no dispute the judge did not make an inquiry.
Sorry?
In this case, there's no dispute the judge made no inquiry.
The judge's questions did not elicit any evidence of such bias or partiality. In this case, there's no evidence to show that the jurors possess the state of mind needed to be able to justify dismissal as grossly unqualified. Here, the trial court neither asked nor elicited such evidence, and neither of the jurors expressed any pause or concern about their ability to remain impartial. The court's inquiry revealed no evidence of the required bias or inability to be impartial. Rather, it equated a per se violation of its general instructions to not discuss anything about the case with being grossly unqualified, rather than establishing impartiality. So here the trial court wrongly and erroneously dismissed two jurors by entertaining a wrong view of the law, equating a general violation of its instructions with being grossly unqualified. And we ask this court that reverse the conviction because the trial court erroneously discharged these two jurors. Unless there are any further questions, we request this court to reverse the trial court's conviction.
Thank you very much.
Thank you.
From your adversary.
Good morning, Your Honors. Jillian Lewis for the respondent. Your Honors, here it is clear that the trial court properly exercised its discretion in discharging two jurors for deliberating prematurely. Your Honors, the facts of this case are clear.
Is it your position that if a juror violates the instruction to deliberate prematurely by having a conversation with another juror, that means that they're prima facie unqualified and must be discharged?
Not if they were merely just having a conversation, but that's not what happened here. What happened here is these two jurors were having a conversation on the subway, and it was later entered into evidence by the trial ADA that...
So is it the fact that it was on the subway that makes it a prima facie, that makes them prima facie unqualified as jurors?
What makes them unqualified is that they were discussing the how they would vote. They were discussing the evidence at issue. They were discussing material facts that constituted premature deliberation.
Don't the cases say, doesn't the Court of Appeals say in Spencer that the record must convincingly demonstrate that the sworn juror cannot render an impartial verdict for him or her to be disqualified? So isn't it more than you violated my rules, you talked about it, goodbye? Didn't the judge have to go further and say, could you, do you feel you could still render an impartial verdict notwithstanding that you violated my instructions? Didn't they have to do that extra step according to this case?
So while those cases talk about the inquiry, the judge is afforded wide latitude to use all of the information at his disposal. And here, knowing that these two, the juror and the potential juror, had this conversation outside of court, talking about the facts of the case, the witnesses, given that information, and the fact that he had told them 6 times prior to that, not to discuss the case, not to deliberate.
Well, we know we do that. Trial judges do that every time the jury gets up. I mean, it comes out like we do it all day long. We all know that, but and we know in this case that they were talking about it. Everybody admitted it. But I'm just saying, I just seems to me there has to the standard is higher and there had to be more.
Well, after the assistant district attorney who had overheard them came to the court, identified that those were the two, it seems that the judge here in conducting the initial inquiry, merely wanted to confirm that these were the right jurors, that these were the people that they were referencing. And once he got the confirmation from the initial juror during questioning, there's an off-the-record conversation between defense counsel and the prosecutor about perhaps the content of what happens, and then
What is the content of the conversation provided to the judge before or after his ruling?
So it's not clear what happened in that off-the-record conversation and how much he knew.
That's the problem with off-the-record conversations.
Yes.
I agree.
But however, the court gave the trial ADA an opportunity on the record to make a more complete record, and he did that on page 522.
That's after he made his ruling.
That's after he made his ruling, and that was to go to the content of the conversation, and it really described the different things that were discussed, the length of the conversation, that there had been a gun, and at that point
Wouldn't the judge need to know that beforehand, so that in the inquiry, and I don't think your adversary referred to as evidence, it's not really evidence, but there had to be an inquiry of the jurors. Did you say this? Did you mean this? Did you, in light of this, can you keep an open mind? Have you made up your mind on this issue? I mean, it was like third-hand hearsay. They came to the judge, notwithstanding it didn't have to be, admissible evidence, but it was somebody told, an assistant to the ADA told them that they overheard a conversation. That's enough, really?
Well, Your Honor, that was never objected to at the time of...
It was already ruled on, though. It was ruled on. He already made the ruling.
But the further questioning wasn't objected to because the initial questioning happened, then the off-the-record conversation happened, and before the ruling, the defense counsel never asked for a further inquiry, never asked for that assistant district attorney that had overheard them.
True enough, and I don't know that they raised a constitutional objection, even though they're entitled to the jurors that they're entitled to. They have a right to their jurors, that they've been duly selected, unless they're grossly unqualified.
And here they were, and it's clear.
But how do we know they're grossly unqualified, given that he never questioned them on the record, so we don't have the record of what happened. That, it seems to me, is key. And in the absence of a record of what it was that that the judge relied on in deciding they were grossly unqualified, how can we possibly determine that it was appropriate?
Well, they had explicitly violated his
That seems to, for me, and we know that some of this is not on the record, but what is on the record is I am not having jurors sitting who are in violation of my instructions. It seems to me that there's at least a possibility here that the judge was more annoyed that they didn't listen to his instructions than that they were grossly unqualified and that they weren't able to render a fair verdict.
If I could just briefly respond.
You may.
In People versus Knight, there a juror was found to be grossly unqualified, not because there was premature deliberation or anything like that. In that case, there was a juror who had outside work, different things going on, and just because of that, on that alone, he was found to be grossly unqualified because he couldn't keep an open mind throughout the process. And that's what happened here. Because they had been talking in violation of his instruction, he did not believe that they could fulfill their role as jurors and continue.
Okay, thank you.
Thank you.
Rebuttal?
We've got to go with the facts. What? Have to go with the facts, yeah.
I'd just like to respond first to the assertion that the court's inquiry confirmed what the prosecutor said. This is not the case. If we look at what actually came out during the Buford inquiry, that is not what was said by the jurors at all. At most, the court elicited that there was some discussion of demeanor, but that does not indicate that the jurors were incapable of rendering an impartial verdict or now possessed a level of bias. Instead, the respondent is relying upon prosecutors' hearsay upon hearsay. This recollection is what the prosecutor told the court that her colleague told her that she overheard on the subway. Under People v. Buford, what is relevant here is only the evidence that came up upon inquiry. The trial court has to conduct a probing and tactful inquiry of the jurors to assess whether they now possess the state of mind such that they are now incapable of rendering an impartial verdict to dismiss them as grossly unqualified. And the trial court can only consider the jurors' answers when doing so. That's not what happened here. In this case, the trial court, rather than eliciting the needed evidence to dismiss them, showing that the jurors were incapable of being impartial, the trial court instead hung its hat on a per se violation of its general instructions not to discuss anything about the case. And as stated, a mere violation of instructions does not amount to being grossly unqualified to serve. It does not amount to the needed showing of partiality or bias or premature opinion as to guilt or innocence formed. Here, we did not see that the jurors had closed their mind to the remaining evidence. And furthermore, the prosecutor had a full and fair opportunity to ask the court to elicit more evidence if they believed this wasn't the entirety of the facts, but they did not do so. All we can consider is what was elicited upon inquiry.
Thank you.
Thank you.
Thank you both. Harris versus City of New York. You may proceed.
Thank you. May it please the court, Glenn Kaminsky with the firm Amity Demers McManus, counsel for the Appellant Safety and Quality Plus. The court below erred in failing to grant dismissal of the Labor Law 241-6 claims as to all parties. To have a 241-6 claim, the plaintiff must plead and prove a violation of a specific regulatory standard. That violation must be the proximate cause of the injury. Here,
Counsel, before we even get to the merits of that claim, there's a few procedural issues. And one issue is, what ability does the appellate court have to consider that argument if the argument was never raised below, since it was never argued below that that claim should be dismissed on the ground of lack of notice?
well, in fact, the provision was put at issue in the matter below. The city motion at page 49 clearly argues that there's no violation of 23-1.5.
No, I mean the specific argument about notice.
I'm sorry.
The specific argument about notice was not put to the court below.
I can't disagree, Your Honor. Respectfully, I can't disagree.
What then is our right to consider it
Because
in light of the
this
fact that it wasn't
is
raised?
one of those cases that fall into that rare exception that we see in Bisli, where even if this were to be argued for the first time on appeal, okay, it is a dispositive point of law that cannot be avoided on these facts. And the facts of this case clearly show that there is no notice to any party involved in this litigation. And because the law is very clear that a violation of 23-1.5C3 requires notice, that being decisive, this court has full authority and should in fact rule on this point.
Let me go to the next question. How are you aggrieved?
Well, we're aggrieved. First, we moved broadly for 241. Of course, we have been granted summary judgment as to the plaintiff, but the case was then severed as to our party based upon the contractual indemnity claims of the city entities. We are basically a third-party action, a third-party defendant who, of course, always has the right to raise the issues of the party who is suing them. So we didn't get full relief because we're still in this case. And as a party still in this case, we have the right to raise the defense of the party who has brought us in. It's all in our reply brief showing that we are clearly aggrieved.
Let me ask you, why is this a dispositive issue of law? Obviously, the First Department has never actually ruled yet directly on the issue of whether notice is required under this industrial code provision. why should we rule that notice is required, and why is it dispositive on the record before us in this court?
Thank you, Your Honor. Well, let me address it this way. Notice has been required under the statute. Misicki, the Court of Appeals, made it very clear that 23-9.2a is indistinguishable, basically, from 23-1.5c3, and that Misicki Court required that notice is an essential element of that code violation. The Fourth Department in Shaw versus Scepter, which is cited at page 14 of our brief, made it clear that notice was required for a violation of 23-1-5c3. The Second Department did the same thing in Nicola versus United, page 13 of our brief. This court looked at these types of cases, 23-9.2 and 23-1-5c3, in Becerra. In Becerra, the court didn't have to rule on notice because notice was essentially presumed there. In that case, notice, the foreman gave the defective grinder and told the employee to use it. 10 days ago, this court, in Verwet versus Purvis, cited Becerra again, and Becerra is cited at page 13 of our brief, by the way, cited Becerra again, in another case where notice is essentially presumed because the plaintiff was directed to use a visibly defective grinder. Here, we don't have that kind of presumed notice, but we have the authority of the Fourth, the Second Department, and we even see in Zuniga versus BRP, cited at page 14 of our brief, the Supreme Court, New York County, providing and setting a notice standard. And since it's a point of law, it's decisive, because once there's no notice, and here are the facts.
Let me ask something. Why is the notice we're talking about under the industrial code the same notice that we're talking about in terms of the determination the court made below, finding that the city didn't have notice for purposes of Labor Law 200 and the common law negligence claim? Why are those the same notices?
Well, I'll even go a step further. It's not even that the city doesn't have notice. They don't have notice. And and they would hold the city in for 200 if they had notice of a dangerous condition. This is alleged that this is the sole dangerous condition. They don't have notice of it.
Is your contention that the notice that we're talking about in these Industrial Code 2315C claims the same notice that's being referenced in the 200 negligence claims?
It is the same notice, and what I'm trying to explain here is that if they have notice of a dangerous condition, this is the only dangerous condition that is alleged. This is it. So if the city doesn't have notice of it, then there can be no claim there. But it's not just the city, because Del Toro testifies there's no notice to safety and quality. The plaintiff himself, I'll be happy to go through every fact that tells you the plaintiff himself doesn't have notice. He's been in and out.
I'm going to suggest you don't go through every fact, because one of my colleagues wants to ask you another question, even though your time is up. We'll look through the record.
So on Becerra, I agree with you that Becerra holds that Section 23.1.5C can state a basis for claim under 241.6, and that we reach that conclusion by comparing it to 23-9.2A. But in reaching that conclusion, we didn't say that what's similar about those two provisions is the notice provision. And in fact, we pointed out that 23-9.2A says upon discovery, and there's no similar language in the section we're talking about. So I don't understand how you can conclude based on Becerra that a violation based on 23-1.5C requires notice in the same way that a violation based on 23-9.2A does.
Well, respectfully, looking at the 23-1.5 C3, what is in order that it was ruled specific, right, is because it had to contain a direct command, right? That's how it was held. And here it shall be immediately repaired.
Right, but in
restored or immediately.
In 23-9.2a, it specifically says, upon discovery, anything shall be done.
I
There's no
understand.
similar language in 23-1.5c.
And I'm saying respectfully that the immediately repaired, stored, or immediately removed has to require notice because you can't immediately repair it unless I've seen it. I can't restore it unless I've seen it. And as the Pina case cited in our paper says, that minor variations in statutory language doesn't mean that they don't mean the same thing. If not, I'll hold out for a rebuttal on the contractual liability and any other questions.
Thank you.
Good afternoon, Your Honors. May it please the Court, my name is David Perisman, and I represent the plaintiff respondent. It's not that I wouldn't like to see a ruling from this Court that finally lays out whether 1.5C3 or other regulations dissimilar to 9.2A, which call for words like upon discovery. It's not that I wouldn't like to see this Court say notice is not a requisite. It's not necessary, however, because the type of notice, it's not the type of notice that matters, it's who has the notice. And when you read Rizzuto, what the Court said was that the owner and GC don't have to have notice. In this case, the GC is my client's employer, but someone in the chain does. And if someone in the chain of construction has that notice, that flows up. If the employer has notice, or as in this case, caused and created the condition, since they were the only contractor on the site, and every condition there was done by them, and everyone agrees that they were taking this piece of wood on and off willy-nilly, that ends it. They caused and created the condition, and their acts bind the owner, the city of New York. So I don't think it's a different type of notice. I think it's who has the notice. That's why when the Court ruled that there was no notice under Labor Law 200, they were necessarily ruling about the owner, the city.
Didn't they also find there was no notice as to SQP also?
Yes, but
who
SQP
has
wasn't a
the-
subcontractor either.
So who has the notice?
The employer, the people who created the whole site. SQP didn't create the site. Plaintiff's employer created the site, Waterworks. They were the GC and the sole contractor on that site.
Isn't there always notice, under the argument you're articulating, there's always notice then? Why would notice even be an issue? When
No,
would there not be notice under the,
if there's a defective condition and it's not,
that rail went up and down, it wasn't one way all the time. It was a rail that moved. And what the allegedly defective condition is that the way the railing was positioned at the time, that's the defective condition, not the fact that the rail existed or that there was a rail. That obviously was not in that position all the time. So what we're talking about is whether there was notice at the time of the accident as to the way that the
whatever,
condition.
I understand. I don't want to cut you off.
Go ahead.
Got it? Okay. Whatever condition that board was in at the time was caused and created by one of Waterworks' employees. They were the only people on the site.
I want to follow up with my colleague's question then. So whenever you have a cause and create kind of situation, then notice exists because somebody had to have notice of it.
That is notice, caused and created.
That's your argument.
Yes,
That's your
caused
argument. But it doesn't matter who caused and created it in terms of your interpretation of the notice that may be required under this industrial code.
No, as long as it's a subcontractor for whom the owner is responsible vicariously under Labor Law
Edification,
241-6.
Where is this argument in the brief? What pages on the brief is this argument?
This is
Where in the brief is this argument?
Where is this in my brief?
Yes.
I don't know. Oh, it's throughout my brief. What we say over and over again in our brief is, let me get the exact language so I don't.
So in other words, in your brief, whenever you refer to vicarious liability under this provision, that's your argument regarding notice is if it's cause and create, notice to anybody suffices?
What we argued in our brief was at multiple points in time, we said, when we said about the issue of the requirement of notice, is particularly when someone else in the chain of construction caused and created the condition as they did here. And I think we said it at least 5 or 6 times in our brief. I was reading it this morning. I want to get to the precise citation, which...
That's a novel proposition, though.
It's an...
Novel. You don't have any case law that says that.
I don't think it's...
I don't think we have any case law
under
that says it because we don't even have a case that says notices.
Under negligence concepts, when somebody causes and creates a condition, you don't have to prove they knew about it. You did it with your own 2 hands.
Right, I understand.
The common negligence concept.
I get it, but we're talking about under the 241-6 vicarious liability, this particular industrial code.
I don't know.
Which, if it requires notice, is somewhat of a subset in the industrial code. It's not, most of them don't.
But it doesn't make sense that you're going to require a subcontractor, a plaintiff to prove that a subcontractor who created a condition had notice of what they created. It just doesn't make sense. And by the way, I don't have the record site, but it's in my brief at page 18. Therefore, if plaintiff's employer created the dangerous condition here or otherwise had notice of it, the city may be held liable at trial, irrespective of the fact that it might not have had that notice itself. And we say it in multiple other places in our brief. And I remember it because I'm the one who went through this brief and kept putting that in there because I thought it was important that it's not a question of whether the city has notice. It's a question of whether someone in the chain has notice. And I derive that from Rizzuto. Because in Rizzuto, they said, well, they didn't have notice, but someone in the chain had notice. It's liability.
What kind of claim was Rizzuto? What kind of industrial code claim was Rizzuto? What I'm trying to ascertain is whether any of these, because this does sound very novel to me, what you're arguing, whether any of these cases that analyze the notice requirement under Industrial Code 2315C ever articulate the proposition that you're now stating. Do anybody say as long as someone on the chain of command has noticed, that's...
I don't think so.
Or is this a novel proposition that you're now bringing to us? Is there any case where notice is a separate component? Because notice is not normally a component, as you argued in your brief, of an industrial code provision. It's only very specific industrial code provisions because it's something about the way the industrial code provision is worded that brings up the notice issue. So in any of those cases which involve an industrial code provision that has a separate notice requirement, such as Industrial Code 2315C or the 191, does the court ever articulate the proposition that you are articulating, that we could go look to that case and say, oh yeah, this is the law, this is what a court has actually held?
I
Can you
can't
cite
say.
one case like that?
I can't say I can cite to a case. I think it's as natural as it comes.
So there's
because
no
it's a
case that
negligence
says that.
concept.
It's a negligence concept, but this isn't a negligence.
241-6, at least I hear from my defendants all the time, that requires that proof of violation of a regulation is some proof or some evidence of negligence, and then the plaintiff has to show that the conduct was otherwise unreasonable. Truth be told, it's not some proof, it's the only proof, because you can't prove anything else other than a violation of a regulation. But once you go there, you have to, it seems simple and logical that if somebody caused and created a condition, why does somebody have to prove they knew about it when they did it?
You're talking about 241-6 cases generally. Okay, I'm looking at
I
you.
am
Now I
speaking,
understand the argument you're
and
making.
I can't tell you that there are that many cases. 1.5C3 hasn't been spoken about that often in the courts because 1.5C3 wasn't held to be a specific regulation until a couple years after I argued Misicki. And when I argued Misicki and they held 23-9.2A to be specific, then they said because 1.5C3 has similar provisions, it too must be specific. So there isn't much case law about it. But I still would love to see the court say something about regulations not requiring notice, because it is not as clear as we would like it to be. And I do also, just to close, agree with the court. It seems, based on the court's questions, that, or at least it's my argument, they can't even bring up the issue of notice. They never brought it up in their papers below.
Thank you. All right, let's hear from the city.
May it please the court, my name is Nicholas Herzler, and I represent the city respondents. Your Honors, I think where the appellant goes wrong is trying to equate the arising out of the work standard from the contract with a negligence standard of they're saying, well, basically their argument, as I understand it, is that there was no notice in the lower court's determination, therefore this accident did not arise out of our work under the contract. And what I think the reason why I think that's incorrect is because it's well settled under cases like Brown and O'Connor that we cite in our brief that arising out of the work is a much broader concept. It means anything having to do with the work of SQP on the site. I'd like to quote from this court's decision in Masciata versus Morse Diesel, which we cite on page 21 of our brief. Quote, plaintiff's injuries arose out of property's work and or an act or omission. The accident happened in the area where the property's work was being performed, which is true in this case, involved a property employee, which is true in this case, and occurred during the performance of property's work. In other words, you know, the whole point, the entire point of hiring a safety consultant is to prevent things just like this. I mean, I'm not conceding that they're correct that there was an industrial code violation. We agree with the appellant that there was not. But in the event that this court finds a question of fact, it's our position that the whole point of hiring a safety consultant is to prevent, specifically to prevent an industrial code from occurring. And if you look at the contract at page 1049 of the record, it talks about a safety consultant is supposed to identify deficiencies, go out there and find them and report them, conduct and schedule safety meetings, talk about these things in meetings, proactive.
So your essential claim is that arising out of, in this context, encompasses failure to detect, which would be, I guess, a contract violation. Is that your position?
Well, as defined in the contract, it's not just it's not a negligence standard. In other words, I would.
I'm not disagreeing with you, but you're saying that it's broad enough here. What they did is they didn't detect it. That's the best you can say about them, right?
Well,
They're the site safety manager. They didn't detect it.
I mean, we're here on a summary judgment motion, so it's their burden of proof to rule it out. And I mean, could it have been brought up in a meeting? Like, you know, this piece of wood shouldn't be like this? Could it have been proactively addressed in some way? We don't know because they don't tell us, as far as their prima facie burden on summary judgment, to say everything was done under this contract to prevent this problem. And, you know, when you look at how broad the standard is under the case law, all the things that they were supposed to do under the contract, and then you look at, you know, the contract, which is an enforceable language, any claims, I'm looking at the record 1052, any claims or causes of action of whatever nature arising from the work, including all claims relating to its subcontractors, suppliers, or employees. So basically, we think the indemnification claim must stand on this record because it's a much broader claim than the negligence claim, although we fully agree with their position that the industrial code provision does require notice and that the Labor Law 241-6 claim should be dismissed.
I just have a question. Now, didn't the city also move for summary judgment where the city argued that SQP also did daily inspections? Didn't you raise that on the summary judgment motion?
That we argued that there was...
Del Toro, that he conducted daily inspections of the site.
Yes, we argued, of course, that but again, it's not just the inspections. I mean, there are other things that they were supposed to do under the contract. They were supposed to take, proactive measures. They're supposed to have meetings. They're supposed to address these things, regular site safety meetings that are conducted weekly. And those things are much broader than the standard of actual and constructive notice as defined in the case law or as defined in the case law specifically with respect to the industrial code. Unless the court has any questions.
Right, could you address, since you agree with Site Safety's argument regarding notice, can you address the plaintiff's argument that anybody who gets notice under that industrial code will suffice?
Thank you for asking that question. That is completely, that is very, there's no support in the case law for that. In their brief, I read their brief, and they cite Rizzuto, and they cite all these very generic Labor Law 241-6 cases for the idea that it flows up to the owner or general contractor, but there's no case law, as was pointed out earlier, that, for a specific industrial code that has a notice requirement, which are somewhat rare, that in that instance that they just, that they can somehow just say, well, if it was created by somebody, then automatically there's...
Well, if you didn't have that restriction, wouldn't that turn the industrial code provision into a common law? Wouldn't it be identical to a 200 claim then? I mean, if you have an industrial code provision that is specific enough to otherwise support the cause of action, and you say it needs notice, and the notice has to be to the person that you're looking to hold vicariously liable, isn't that the same kind of liability that you'd find just under negligence or 200? What makes it different then?
Well...
You understand my question?
I believe so, and my response to that would be, as Appellant cited a second department case and a fourth department case saying that there's notice for this particular industrial code provision. What I think is really significant is that they use the word notice, and notice is the same exact word that's used both in those cases and in any notice case. In other words, they didn't qualify that word notice. They didn't say it's notice, but it only, in the context of the industrial code, it has to be different in some way. Notice equals notice. They use notice, and it's the same thing in those cases, and this court should be guided by the second department and the fourth department.
Okay, thank you.
Thank you.
I will agree with learned counsel that there's no support for the position taken by the plaintiff in the case law here. And in fact, counsel engages in just speculation as to how the 2x4 got to where it is. The fact of the matter is, plaintiff's own testimony was that he never noticed a 2x4 before. That despite going the same way in and out at about the same time, he didn't notice this condition. The first time he saw the 2x4 was after. So we don't know that any waterworks employee was the cause for this to be on, that they caused and created it. It could have fell off its marking where it was. We don't know, so we can't engage in speculation and this cause and create argument.
I don't understand it could have fell out. It was put in. I mean, that's undisputed.
It was a railing put 4 feet high, all right? It's also undisputed that they did lift it up and put it down. That's undisputed. But how it got into the state that it was at the very time of the accident, no one knows. Like I said, plaintiff himself didn't see it when he went in, didn't see it when he went out. He only saw it the first time after he fell over
Was
it.
there
So
testimony that that happened regularly?
there was testimony that they would lift it up to move it. That's why it's not even a dangerous.
Yeah, so they got in, so they could easily get in and out of the area while they were working, right?
Which is why it's not even a dangerous condition. It's not even a breach of any problem to begin with, because this is what they typically do. Matter of fact, when plaintiff went back to take photos, right, he testifies it was there. I had to lower it in order to put it to the position. So simply put, there's just no support for plaintiff's position. As to the contractual indemnity claim, I'll just say this. Most of it's in our brief. Except for the brief, it doesn't arise out of safety and quality's work. And this is acknowledged actually by the city defendants at page 40 of the record, paragraph 46, where the city says, Waterworks was exclusively responsible for taking action with respect to the construction, repair, maintenance of the trench, and railing system. All safety and quality did was to inspect. I respectfully refer the court to the Maldonado case cited at page 17 of our brief, referring to site safety, and I think the logic there should dictate here, and the case should be dismissed.
Thank you very much. Thank you all.
Thank you.
Signature versus Garber. Step up, please. You may proceed.
Good afternoon, Your Honors. John Waite on behalf of Appellant Simon Garber. Your Honors, getting right to it, the issue here is that summary judgment was granted in favor of the bank, notwithstanding a sworn affidavit submitted by Mr. Garber, in which he explained that the promissory notes that the borrowers entered into were modified after he had a series of meetings.
Is there any documentary evidence of any kind to support this claim of oral modification?
There's no documentary evidence, no, other than his sworn affidavit. That's all we have.
Allegation that this oral modification was entered into.
I'm sorry, Judge.
Just his conclusory allegation that the modification was entered into.
It's in his sworn affidavit, and there is no.
Does the guarantee have a no modification?
It was never. I'm sorry, Judge.
Does the guarantee have a no modification clause in it, no oral modification clause in it?
It does, Judge.
So how does this purported alleged oral modification satisfy the requirements of the GOL?
Because there was actual performance by the borrowers, meaning that.
What performance was there by the borrower other than what would have been the normal performance if this oral modification had not existed? What was different?
According to our client's sworn affidavit, again, after they entered into that agreement, the borrowers increased the amount of their payments for a period of 12 months, after which it was their understanding that the bank was going to enter into a new deal with them where they would have lower payments.
And is there proof of those increased payments?
There is no proof in the record of those.
Proof in the record of the increased payments for the 12-month period?
There is neither proof in the record of the increased payments, but it is a disputed.
So how can that be proof of satisfaction of the GOL requirement if there's no proof in the record that these increased payments were ever actually made?
Well, all that we have in the record is our client's affidavit saying that.
This is summary judgment. I mean, this is summary judgment. So at some point, obviously, that's just not enough. And if you can't put it forward now, how can we, how can we consider it on summary judgment motion just based on the affidavit?
Okay. Well, maybe I should move on to the next thing, which is that when we turn to the issue of damages, and these are all kind of related, the court entered a judgment against our client in the amount of $33 million, essentially based on a chart that was put together by an executive at Signature Bank. And there was no underlying source documentation showing the amounts of money that the banks received in terms of checks, wire payments, anything along those lines.
Well, nothing barred your client, nothing that was based on the numbers in the promissory notes, and your client certainly could have put in documentary evidence with regard to the amount at issue, but failed to do that, right?
It is true that our client did not put in documentary evidence.
So why shouldn't we just rely on the number that was based on the promissory notes that are actually in evidence, that are actually before us?
Because while the notes are in evidence, the notes essentially state what was to be done, but for the bank to recover $33 million, it needs to show how much money it received and how much is outstanding, and that's what it didn't do.
But, I mean, the thing is, didn't you, once they put forward what they did you raise any questions like, oh, no, I gave $1 million and that wasn't considered? I mean, was there any issue that you raised so they could go back and give more detailed information? I mean, once they put forward a number, unless you really raise some kind of issue, I mean, you know, they obviously someone in Signature Bank put some information together. So that's what I'm concerned about. I don't know what, you know, other just than throwing out possibilities, what substantively did you have to show?
The only way I can respond to that, Judge, is that it's the bank's burden on summary judgment to establish the amount of their damages. And what they've essentially done is put in a sworn affidavit from an executive that either says he has personal knowledge or he's reviewed the records. And he's basically said, under these notes, these are the amounts that would be due, which is different than saying, you know, here's the documentation showing the amounts that the bank received.
Thank you. But given that, okay, go ahead.
Go ahead.
No, it's all right.
All right. All right, we'll hear from your adversary.
May it please the court, my name is Robert Tills of Mord, Hock, and Hamroff, and we're the attorneys for the plaintiff respondent, Signature Financial.
Let's start with the damages. What did you put in to prove damages in terms of the non-payment of these notes?
Okay, the issue of damages in this case is actually quite simple, because what the evidence establishes in the record and with the affidavit from Signature Bank, and the defendant does not dispute that they only made 12 payments under the note. And the affidavit from Signature Bank says that the payment amounts were in the exact amounts set forth in the note. Therefore, the amounts of the payment are not an issue in this case. Signature Bank wasn't required to put in specific evidence of the amount of every payment made.
No, but were they required to at least say, and I don't know, maybe your affidavit says it, that the officer at Signature Bank went and reviewed the bank's business records, and based on the business records, this is what they found. The notes say what they say, but there's got to be a ledger someplace maintained at Signature Bank that has the payments made, when they were made, the credit to them, and what the balance due was. I mean, that's just general business.
I believe that the affidavit does say that. I can go grab the record and double check and cite to the exact paragraph.
Okay, well, take a look at it, because you and your adversary seem to be at odds, and I don't have the affidavit right in front of me right now, you know, to see, you know. We'll look at it. You know, we know where to look for it.
It's on page 40 of the record, Your Honor. It's in the very first paragraph of Stephen Ratner's affidavit. And he says that his knowledge is based upon his personal knowledge, or from a review of the books and records maintained by Signature in the ordinary course of its business.
Okay.
And the issue of the amount of payments was never an issue. Both sides in this case agree that there were 12 monthly payments made. The defendant's argument is that those monthly payments were on account of some oral modification. But
Well, it sounds like he's claiming that the amounts were different than what's provided for in the note, that he increased the payments. Do you?
he did not. And again, that's addressed in the Ratner affidavit. And so just just give me 2 seconds to go quickly through what the notes provided. There are 28 notes, all dated June 25th, 2015, and that's very important. There was one interest-only payment and then 36 payments of principal and interest with a balloon at the end. And the amounts of the payments were expressly set forth in the note. And this modification that the defendants allege took place, the defendants allege that the modification was in August of 2015, 2 months after the note, and the defendant alleges that the oral modification provided for the borrowers to make increased monthly payments. But they put in zero evidence of increased monthly payments, and Mr. Ratner states in his affidavit after reviewing the bank's records that all the payments were in the exact amount of the note. But even more importantly, the defendant alleges that the loan payments were all interest only, and that in August 2015, which is 2 months after the note was signed, there was an oral agreement to modify the payments to principal and interest. Well, that's not a modification at all. The notes expressly provide that the payments are going to be principal and interest. It's clearly stated in all 28 of the notes. So his argument that there was some modification is just incredulous because it makes no sense, because the modification that he's alleging are the terms that are set forth in the note. So I really don't understand the logic of this argument that they're trying to put forth. And if there are no other questions that the court has, we'll just rest on our brief with regard to the other issues that were raised by the defendant.
Any questions, colleagues? Okay, thank you. Thank you both.
Thank you, Your Honor.
People versus Darnell Hardware. You can proceed.
Thank you. Good afternoon, Your Honors. Matthew Christiana on behalf of Appellant Mr. Darnell Hardware. The indictment in this case was jurisdictionally defective because it failed to charge Mr. Hardware with a specific particular crime and failed to allege acts constituting every material element of the underlying offense. In this case, Mr. Hardware was charged with persistent sexual abuse under Penal Law Section 13053. Now, Penal Law 13053 is unusual in that it doesn't necessarily have elements in the traditional sense. Instead, in order for somebody to be charged with the offense, there's two separate requirements. First, that the person commit one of three present qualifying misdemeanor offenses, and then two, that they have also been subject to a conviction for those same one of the three.
And they have to give you a notice to let you know which one they're talking about, right?
Yes, Your Honor.
And you feel that your client did not get notice of that before, I guess, before the trial?
Yes, Your Honor, and there's two separate arguments relating to this. The first one being more of a jurisdictional level and the fundamental level that Mr. Hardware was not charged with a particular crime, which is a non-waivable issue, and that's the primary argument that we're making here today. Of course, notice as a separate issue that was brought up by respondent, but for our purposes here, the crux of the underlying offense is this underlying misdemeanor offense. Penal Law 13053, really in operation, is a sentencing enhancement. It bumps that misdemeanor to a felony. So the crux...
And the indictment didn't distinguish which one of the qualifying present offenses they were charging your client with, or they were claiming your client committed.
Yes, Your Honor. In this case, the indictment simply stated that Mr. Hardware The grand jury found Mr. Hardware committed 13053, and then it says as follows, and it alleges only that he subjected somebody somewhere to sexual contact.
And that sexual conduct would have been an element of any one of the three, but not the complete elements of each of the three.
Yes, exactly, Your Honor. The sexual contact, it's the shared actus reus amongst all three. And of course, on its own, sexual contact is not a crime. It has to be coupled with something else. And that is precisely the deficiency in this case, that there was no specification for the underlying offense, the crux of the conduct that Mr. Hardware was being hailed into court to defend against.
This argument was never raised below, is that correct?
No, Your Honor. This specific argument, or in fact, no argument with respect to the indictment that we're raising was raised below. However, this jurisdictional argument relating to the particular crime and the failure to allege the elements is a non-waivable defect. So it's properly before this court at this time. And I will just say one final thing on this. The statute does reference 13053, which under the Cohen test would incorporate all the elements, but in this case that still does not solve or cure the deficiency because, again, it does not specify the crux, the underlying misdemeanor offense. And in fact, Penal Law 13053 specifically states each underlying misdemeanor in the disjunctive, that the person has to have committed sexual abuse in the second degree, in the third degree, or forcible touching. So in this case, merely just incorporating the possibility of 3 different possible crimes does not specify or state a particular crime.
Okay, thank
Thank
you.
you.
Thank you. Let's hear from your adversary.
Good afternoon, Your Honors. May it please the Court. My name is Sheila Bautista, and I represent the people in this case. Your Honors, this indictment provided defendant notice of 3 possible crimes he could have been prepared a defense for.
But why is that good enough? Why is it okay to have 3 possible crimes as opposed to one certain crime?
Because the purpose of an indictment is to provide notice sufficient to prepare a defense. The defendant could have prepared a defense to any one of these crimes.
Why should he have to prepare a defense to 3 possible crimes without being told which one you're charging him with?
Well, it's common for an indictment to charge multiple crimes and for the people to proceed to trial with only one crime.
Well, but you could have charged 3 crimes.
Correct.
But you didn't do that. You charged 1 crime but didn't say which crime you were talking about.
Your Honors, this indictment incorporated by reference all 3 possible crimes, including the ones that were mentioned in the complaint. The
Do we
defense.
have to guess and wait till the end of trial to figure out which crime he's being charged with?
Your Honor, it provided notice so he could prepare defense to any one of these crimes, because based on the.
But how could he know which one he needed to prepare the defense to, or to never allege which of the 3 crimes he's being charged with?
Based on the facts that were alleged in the complaint, because the facts.
But those
could have
apply
set.
to any of the 3 crimes.
Correct. So the
You're
defendant.
saying it's okay for him to have no idea to the end of the trial which crime he's actually being charged with? There's no problem with that?
He could have prepared a defense to any one of these crimes. At the time of trial, he was only charged on one. Your Honors.
But based on what you're saying, because he'd have to guess, he'd have to prepare a defense to all 3. I mean, how would he know?
His defense is based on the facts of the case, and he was provided.
I don't know what that means. Okay, let's step back for a minute. You know, let me get at this a different way, all right? Certainly there's law that by putting in the penal code into the indictment, that in most cases will satisfy your burden because the penal code has the elements. Here, this particular crime had 3 possibilities, right, of different parts of the penal code, right?
Correct.
3 different, and those, while they had the commonality of the sexual conduct, otherwise they had different elements, correct?
Correct, Your Honor.
All right, and those elements were subject to differing proof, correct?
Correct, Your Honor.
And none of the facts regarding those different elements and different proof were set forth in the indictment, were they?
The indictment just has to say what.
I didn't say what it has to say. We're going to decide that.
Okay.
I'm going to say, what did it say? We're talking about the facts.
It said when, it had the date, it said where, New York County, and it said what.
It didn't answer my question. Did it have facts sufficient to satisfy the elements of all three?
Correct. It had the facts of date.
Explain to me how.
It had the fact of the date, the
Well,
location.
no, but that doesn't do it for me, because there are elements of the crime. So now you have to relate the elements of each one of the three crimes to the facts that are said. Of course, that it had the date and the location, it wouldn't be sufficient.
Those are facts, and I wanted to add, it also included sexual contact. Sexual contact.
But you already conceded that sexual conduct is an element of each. Now, as to the individual elements.
Correct. Your Honor, may I add? If I could provide an example, please. For example, once an indictment provides notice, it establishes jurisdiction.
We got that.
For example, let's say we had an indictment for a drug crime that charged possession weight and possession with intent to sell. And let's say the indictment charged both those crimes with similar facts. Those are different elements. Let's say the people, that established jurisdiction, it gives the defense.
But the differences in your example, and it's a great example, is that two different provisions of the penal code would have been pled so that it would be very clear that you were proceeding under different subdivisions of the penal code and what the elements you were claiming were.
Correct. If I could finish my point. Once that indictment has pled the different elements of the different crimes, jurisdiction is established. It provides defendant notice he could be charged with either crime. If the people
But you didn't charge him with the three misdemeanors. You only went full. All right.
Respectfully, Your Honor, if
I read your briefs. I understand your arguments, and we'll parse this out.
Respectfully, Your Honor, may I finish with my? I didn't get to finish. What I wanted to say was.
I think we understand your argument. Actually, we understand it.
What I
It's
wanted
okay. You got your full 5 minutes.
Your Honor, respectfully.
Thank you. No, respectfully. You have to. I'm the one who controls the calendar. I read your briefs. We heard your argument. We may or may not agree with you. I understand it was a tough argument for you because we really grilled you. Maybe we agree with you, maybe we don't. Now you'll have to wait for a decision. Thank you.
One sentence,
no more.
please.
No.
Thank you.
No.
Thank you, Your Honor.
Rebuttal.
Thank you, Your Honors. Just 2 quick points in response. First, I would just like to note that there are 2 separate issues that pertain to an indictment. One, of course, being notice, but also 2, the jurisdictional deficiency itself being separate and distinct from that. And in this case, as far as the elements that are pled in the indictment itself and the crime that was charged, the indictment is deficient, jurisdictionally speaking, because it did not charge Mr. Hardware with the crime. It was either this or that or this, and then it specifically alleged sexual contact, which Your Honors noted is an element of all 3 and standalone is not a crime. And also, with respect to the separate issue of notice, I would like to note that this is a case, in essence, where Mr. Hardware was forced to guess until the end of trial. It was unclear until the elements of sexual abuse in the 3rd degree came out to the jury. And merely conjoining the criminal complaint in this case makes matters worse in that the criminal complaint specified that this was a crime that was committed on a southbound 4 train. If I may just briefly finish this.
Actually, you made that argument in your briefs as well.
Yes.
Understood.
Thank you, Your Honors.
Thank you both.